Colleagues, could I ask that we all take our places so that we can start? I note people are still coming in, so I'll give them a moment or two. Chief Justice Maya, Chief Justice of the Republic of South Africa, Judge Jago, representing the High Court of the Commonwealth of Australia, Chief Justice Barroso, Chief Justice of the Federal Supreme Court of Brazil, Judge Mezer, representing the Constitutional Court of the French Republic, Judge Viswanathan, representing the Supreme Court of the Republic of India, Judge Arsul Sani, representing the Constitutional Court of the Republic of Indonesia, Judge Nok, representing the Supreme Court of the Republic of Korea, Judge Konovalov, representing the Constitutional Court of the Russian Federation, His Excellency Al Zayed, Vice Minister of Justice of Saudi Arabia, President Ozkaya, President of the Constitutional Court of the Republic of Turkey, President Orkekes, President of the Court of Secession of the Republic of Turkey, President Reid, President of the Supreme Court of the United Kingdom, Lady Chief Justice Carr, Chief Justice of England and Wales, Judge Ntsebeza, representing the African Court of Human and People's Rights, Chief Justice Malaba, Chief Justice of the Republic of Zimbabwe and President of the CCJA, Chief Justice Mapalala, Chief Justice of Eswatini and President of the Southern and Eastern Africa Chief Justices Forum, Judge Benini, representing the Constitutional Court of the Democratic Republic of the People's Republic of Algeria, Justice Murray, representing the Supreme Court of the Republic of Ireland, President Cardoso, President of the Constitutional Court of the Republic of Angola, President El Ribeiro, President of the Constitutional Court of Mozambique, Justice Chong, representing the Supreme Court of Appeal of the Republic of Singapore, esteemed colleagues of the South African judiciary and other judiciaries present here today, Mr. Laraba, Secretary General of the CCJA, Mr. Mufa, UN Resident Coordinator in South Africa, Mr. D'Souza Godoy Guilherme, representative of UNESCO, Mr. Musindo, Director of ILO in South Africa, Mr. Filtane, representing Juta Publishers, members of the legal fraternity and academia, members of the media, members of the public following these proceedings via media platforms, esteemed guests, ladies and gentlemen, good morning. That's a muted good morning. Good morning. On behalf of the judiciary of the Republic of South Africa, and indeed on behalf of a nation reborn through justice and the rule of law, it is my profound honor and privilege to extend a warm, heartfelt Africa welcome to you all. We gather here today in this vibrant corner of the African continent, not merely as representatives of our individual nations, but as guardians of a shared global covenant, the unwavering pursuit of justice under the law. The ancient wisdom of our continent teaches us that the philosophy of Ubuntu, umuntu ngumuntu ngabantu, I am because we are, my humanity is inextricably tied to yours, remains relevant. This summit embodies that very principle. The challenges we face, from ensuring equal access to justice, to navigating the digital frontier, to upholding the dignity of every individual, are not confined by borders. They are human challenges, and they demand collective wisdom-driven solutions. We are particularly honored to welcome our distinguished guests from across the G20 nations and our special invitees, including the pivotal continental bodies of Africa. Your presence here is a powerful testament to a truth we hold self-evident, that the voice of the Global South is not a whisper from the periphery, but is an essential resonant chord in the symphony of global jurisprudence. Africa is not a subject of history. It is a dynamic architect of its future, rich with innovation, wisdom, and a relentless spirit of progress. Together, today, we gather under the guiding theme, Justice in a Time of Change, Independence, Innovation, and Cooperation. A vital call to action that invites us to address the evolving contexts in the judiciary landscape, domestically and globally, while reinforcing our commitment to accessibility, fairness, forward-thinking solutions, and cooperation across borders. Independence, innovation, and cooperation are not isolated ideals, but mutually reinforcing. By safeguarding independence, our courts remain trusted guardians of rights. By embracing innovation, we improve how we serve the public. And by fostering cooperation, we extend the reach of justice beyond our own jurisdictions. This summit embodies all three values. In these 2 days, we will have robust discussions reflecting these themes, whether it is preserving judicial independence in a challenging world, balancing technological advancement with fundamental freedoms, addressing climate change through judicial collaboration, or strengthening our united front against cross-border crime. In each session, we will learn from one another and refine our common vision for the evolution of our respective judicial systems. Distinguished colleagues, the stakes could not be higher. In every country, people rely on the courts for fairness and certainty. If independence is compromised, so too is the protection of their rights. If we fail to cooperate, if we lag in innovation, their access to timely justice suffers. If we fail to cooperate, injustices can spread unchecked. Let this summit be a beacon of hope, showing the world that the guardians of justice are neither idle nor divided in the face of change, but active, united, and resolute. This J20 summit provides a sacred space for dialogue, a forge where we can temper the steel of our legal frameworks in the fire of shared experience. It is an opportunity to learn from one another's triumphs and tribulations, to find common ground in our diverse approaches, and to strengthen the bonds of mutual respect and cooperation that unite our judiciaries. Our retired Constitutional Court Justice, Justice Albie Sachs, once remarked, and I quote him, "Rights are not gifts from the state, they are claims that can be made against it, I close quotes. These words capture the essence of why we are here. They remind us that courts exist not as generous benefactors, but as guardians of enforceable rights. And they press us to ensure that our innovation and cooperation across all our jurisdictions never lose sight of the people whose dignity depends on the strength of our courts. Let us use this time to build those bridges. Let us speak with candor, listen with empathy, and deliberate with the wisdom of our offices demand and our citizens deserve. It is our sincerest hope that the discussions held within these halls will be rigorous, that the partnership forged will be enduring, and that the outcomes will leave a lasting legacy, not just in law reports, but in the lives of the people we are all sworn to serve. On behalf of the South African judiciary, I once again thank you all for being here and formally welcome you to the J20 summit. I'm confident that our time together will strengthen our resolve and spark fresh ideas to fortify the rule of law in each of our nations. As we embark on our discussions, let us remember that the principles of independence, innovation, and cooperation are not goals in themselves, but means to better serve our citizens whose rights depend on our vigilance. You are most welcome. You are at home. In many ways, the ideals envisioned in this summit find their clearest expression in the leadership of our own Chief Justice, a true leader who stewards our judiciary with vision, integrity, and courage. Chief Justice Maya has long been recognized as a pioneer, not only the first woman to ascend to the highest judicial office in our land, but also a jurist whose career has consistently expanded the horizons of justice. From her early years on the bench to her historic leadership of the Supreme Court of Appeal and now as Chief Justice of the Republic, she has shown us what it means to marry independence with compassion, innovation with prudence, and cooperation with resolve. Her jurisprudence, particularly in advancing gender equality and broadening access to justice, has given life to the Constitution's promise that rights belong to all, regardless of power or position. A daughter of the soil, a guardian of justice, from the rolling hills of the Eastern Cape to the highest seat of justice, the journey of Chief Justice Mandisa Maya is a profoundly African story of brilliance, resilience, and transformative power. She is not merely a woman of firsts, she is a living testament to the promise of a new dawn. A pioneer who has woven the rich threads of a heritage into the very fabric of South Africa's judiciary. Her path was charted with a quiet determination that speaks of Ubuntu and unyielding intellect that has consistently shattered ceilings. Distinguishing herself from the outset, she was among the youngest women ever to be appointed to the bench, a groundbreaking beginning that foreshadowed her historic ascent. From this foundation, she rose like the baobab, strong, deeply rooted, and offering shelter to others. She became the first woman president of the Supreme Court of Appeal, the first female deputy chief justice, and now the inaugural woman to lead South Africa's judiciary as Chief Justice. Her career is not merely a personal triumph, but a beacon for every young girl across the continent who dares to dream beyond the confines of expectations. Hers is an illustrious career, forging a legacy of principle and progress. Chief Justice Maya's career is a masterclass in judicial excellence and visionary leadership. After her early appointment, she quickly distinguished herself through an incisive legal mind and an unwavering commitment to constitutional justice. Her tenure at the Supreme Court of Appeal was marked by landmark judgments, that advanced fundamental principles, particularly in the crucial areas of gender equality and access to justice for all. As president of the SCA, she revitalized the court's efficiency and fosters the spirit of collegiality, earning widespread respect for her ability to unite diverse judicial voices around a shared vision of fairness and integrity. Her elevation to Deputy Chief Justice in 2022 cemented her reputation as a unifying force and a reformer. In this role, she championed critical institutional reforms, driving the modernization of court processes and tirelessly expanding access to justice for marginalized and rural communities. Her leadership was instrumental in steering the judiciary towards greater independence. Notably, her powerful advocacy for gender parity catalyzed a significant increase in the appointment of women judges, ensuring the bench finally begins to reflect the beautiful diversity of the nation itself. As Chief Justice, she has embraced her role as the guardian of judicial independence with fervor and profound purpose. Her announcement of a groundbreaking sexual harassment policy on behalf of the judiciary stands as a testament to her commitment to creating an institution that is not merely only independent, but also safe, inclusive, and dignified. Hailed as a watershed moment, this policy underscores a fundamental truth. Justice cannot thrive where human dignity is compromised. She is rooted in community and was elevated by her excellence. She was born in the village of Solo in the province of the Eastern Cape. Her epic journey is powered by an academic arsenal that rivals her practical achievements. A BProc degree from the University of Transkei, an LLB from the University of Natal, and an LLM from Duke University in the United States. Her transformative impact has been recognized by no fewer than 4 honorary doctorates, each celebrating her monumental contributions to jurisprudence and gender equality. A devoted mother and wife, Chief Justice Maya carries the spirit of Africa with her, the wisdom of the elder, the courage of the pioneer, and the heart of a nation. She has not merely climbed the legal ladder, she has dismantled its narrow confines and rebuilt it stronger, more inclusive, and more just for generations to come. Her jurisprudence continues to shape South Africa's legal landscape, balancing precedent with progressive interpretations that ensure our Constitution remains a living, breathing instrument for societal change. Through her judgments, her mentorship, and her towering leadership, Chief Justice Maya demonstrates daily that the law is more than a tool for adjudication. It is a vehicle for healing, for empowerment, and for building a more perfect union. She is truly a lioness of justice, and her roar is the sound of progress itself. Ladies and gentlemen, it is my profound honor to introduce to you my leader, our leader, the Chief Justice of the Republic of South Africa, Chief Justice Mandisa Maya.
Thank you for those kind words, Deputy Chief Justice Mlambo. Chief Justice of the Federal Supreme Court of Brazil, Honorable Chief Justice Barroso, Chief Justice of the Republic of Zimbabwe and President of the Conference of Constitutional Jurisdictions of Africa, Honorable Chief Justice Malaba, Chief Justice of the Supreme Court of Appeal of Botswana, Honorable Chief Justice Ketlo Khedzwe, the Chief Justice of the Kingdom of Eswatini and President of the Southern and Eastern Africa Chief Justice Forum, Honorable Chief Justice Mapalala, the President of the Constitutional Council of Mozambique, Honorable Justice Ribeiro, President of the Constitutional Court of the Republic of Turkey, Honorable President Ozkaya, President of the Court of Cassation of the Republic of Turkey, Honorable President Okerkez. He complimented me last night that I pronounced the name perfectly, and now I'm mangling it. Okerkez. President of the Supreme Court of the United Kingdom, Right Honorable Lord Reid. Chief Justice of England and Wales, Right Honorable Lady Chief Justice Carr. Chief Justice President of the Constitutional Court of the Republic of Angola, Honorable President Cardoso. Deputy Chief Justice of the Republic of South Africa, Honorable Deputy Chief Justice Mlambo. President of the Supreme Court of Appeal of the Republic of South Africa, President Molemela. Representative of the High Court of the Commonwealth of Australia, Honorable Justice Jago. Representative of the Constitutional Court of the French Republic, Honorable Justice Metsat. Representatives of the Supreme Court of the Republic of India, Honorable Justices Viswanathan and Bishnoi. Representative of the Constitutional Court of the Republic of Indonesia, Honorable Justice Sani. Representatives of the Supreme Court of the Republic of Korea, Honorable Justices No and Suk. Representative of the Constitutional Court of the Russian Federation, Honorable Justice Konovalov. Representative of the African Court for Human and People's Rights, Honorable Judge Nsebeza. Representative of the Constitutional Court of the Democratic Republic of the People's Republic of Algeria, Honorable Justice Benini. Representative of the Supreme Court of the Kingdom of Saudi Arabia, Ambassador Al-Habi. Representative of the Supreme Court of the Republic of Ireland, Honorable Justice Murray. Representative of the Supreme Court of Appeal of the Republic of Singapore, Honorable Justice Chong. Honorable Justices of the Constitutional Court and Supreme Court of Appeal of the Republic of South Africa and from other jurisdictions, Judges President, Judges, Regional Court Presidents, and Chief Magistrates of the South African Judiciary and other judiciaries present here today, Secretary General of the Conference of the Constitutional Jurisdictions of Africa, Mr. Laraba, United Nations Resident Coordinator in South Africa, Mr. Mufu, Representative of the United Nations Educational, Scientific and Cultural Organization, Mr. Guilherme, Director of the International Labour Organization in South Africa, Mr. Musindo, members of the legal fraternity and academia, representatives from various government departments and Chapter 9 institutions, representatives of civil organizations in South Africa, members of the media, distinguished guests, good morning. Good morning. Thank you. It's a special privilege to deliver this opening address at this August gathering of the heads of the Supreme and Constitutional Courts of the Group 20 members, and to welcome you to the 2025 J20 Summit. On behalf of the judiciary of the Republic of South Africa, I convey our warm African greetings and deep appreciation for your attendance and participation in this critical dialogue. As South Africa prepares to hand over the baton of the Group 20 presidency in November, after assuming the mantle she took over from Brazil in December 2024, a first for the African continent, we, the South African judiciary, are profoundly honored to host a gathering of this magnitude. It is by all accounts the inaugural J20 summit of the constitutional and Supreme Court leaders in Africa, not just South Africa. We are most heartened and humbled by the presence of so many countries colleagues who have traveled long distances from all corners of the world to support this event. We are most grateful too to our colleagues from this continent, from the uppermost tip of Africa, Algeria, all the way down to our immediate neighbor, Zimbabwe, just across our northern borders. And the African Court of Human and People's Rights is part of this group. It cannot be overstated that South Africa carries the responsibility of hosting this summit, not just for herself, but for the whole of Africa, her people, and their hope for a just future. This summit is for us more than a mere diplomatic courtesy. It is a historical convergence, a deliberate and necessary assembly of the judicial guardians of the free world at a time when the pillars of democracy and human dignity are under unprecedented strain, and the very foundations of justice are being tested and reshaped by global change. In the grand tapestry of human progress, there are moments that demand not just reflection, but resolution, moments that call upon the stewards of justice to step forward and affirm power of the law, the enduring power of the law, in an imperiled world. This is one of those moments. The judiciary has always been the sentinel of society, the neutral ground upon which the powerful are held to account and the vulnerable find their voice. We are the custodians of the social contract, entrusted with the sacred duty to interpret not only the letter of the law, but also its spirit, the timeless pursuit of fairness, equity, and truth. And on our watch, the instruments of justice upon which humanity relies to maintain social order and prosperity of her nations are being most ruthlessly tested by a new and alien class of challenges that are amorphous, borderless, and are evolving at a pace that often outstrips the deliberate cadence of the law. It is now not so unusual for our courtrooms to adjudicate cases that involve interests straddling continents. Our court rolls abound with disputes born in the digital realm and difficult social dysfunction, and our precedents must wrestle realities which those who came before us could never have imagined. This meeting stands to show an inexorable evolution in global governance and the recognition that the judiciary is an indispensable pillar in addressing the most pressing challenges of our time. Our forum, the Judiciary 20, is an integral part of the Group 20 and represents the third branch of state in this important forum for international economic cooperation. South Africa is quite fortunate because we build upon the visionary foundation laid by the masterfully curated Brazilian J20 presidency in 2024, which rounded up judicial leaders from around the world to deliberate on social justice, environmental sustainability, and the digital transformation of justice with seeming effortlessness. The South African delegation, which attended the Rio Summit, spoke very highly of their experience there. We are therefore very pleased to have the Brazilian delegation led by Chief Justice Barroso at this event, and we look forward to their contributions to the discussions. Their legacy, which is meticulously documented in their official portal, provides a valuable framework for our continued dialogue and is a powerful model for how the judiciary can contribute to the G20's mission of fostering global stability and sustainable development. It is a bonus that we can tap into that treasure trove physically in these 2 days. The existence of the J20, which was pioneered in 2018 and has recently been revitalized under Brazil's leadership, signals a critical understanding that economic policies, climate agreements, and digital frameworks, and a host of other issues that drive the modern world are ultimately upheld, interpreted, and given force by the rule of law. We are the engagement group that ensures that the commitments made by the nations within the G20 are anchored in legal principles and accessible justice. Through the exchange of ideas and initiatives on contemporary legal topics, we transform abstract goals into tangible rights and protections for citizens worldwide, thereby strengthening the very fabric of multilateralism. J20 Rio de Janeiro powerfully demonstrated this, moving beyond discussion to forge concrete strategies for enhancing judicial accessibility, confronting the climate crisis through litigation, and harnessing technology for efficient justice, all while steadfastly promoting citizenship and social inclusion. We hope to achieve the same results here. The journey to the summit started with a simple request to our peers who are here in flesh today for a special virtual session in July. This would become a remarkable exercise in international coordination and diplomatic ingenuity, organizing a global gathering of judicial leaders from diverse time zones, including the United Kingdom, India, Russia, Turkey, France, Indonesia, Australia, and Brazil, required meticulous planning to accommodate their busy schedules and ensure meaningful participation. The use of technology was pivotal. Video conferencing and virtual collaboration tools facilitated real-time interaction, while advanced scheduling considered temporal dispensation to minimize coordination costs. The inclusive approach to topic drafting, where each participating country contributed agenda items, fostered a sense of shared ownership and alignment with global judicial priorities. This process mirrored the principles of collaborative input and consensus building seen in successful virtual strategic planning sessions, where advanced work and stakeholder engagement are critical for productivity and focus. The acceptance of the invitation by all these nations shows that their firm commitment to strengthening judicial cooperation and addressing transnational challenges such as human rights, rule of law, and sustainable development. Each country brings unique perspectives to the table, and that initial participatory topic drafting phase not only enriched the agenda, but also built trust and cohesion among the participants. The session demonstrated how virtual platforms can transcend geographical barriers to foster dialogue. It set an important precedent for future virtual judicial collaborations, highlighting the potential of technology to enhance international diplomacy in an increasingly interconnected world. Our theme, Justice in a Time of Change, Independence, Innovation, and Cooperation, captures the essence of the current judicial epoch. We have gathered here not merely as observers of this change, but as participants entrusted with the sacred duty of ensuring that justice remains a compass guiding societies through turbulence and transformation. Therefore, our role extends far beyond mere deliberation. We are the architects of a legal infrastructure that supports a more resilient, inclusive, and equitable global future. The documents produced under Brazil's presidency serve as our compass, guiding us to leverage our unique constitutional mandates to implement and oversee policies that secure sustainable development and protect human dignity. As we reflect on this heritage, we must embrace our collective responsibility with courage and clarity, engage in our discussions boldly. We must strengthen our collaborations and make purposeful resolutions to ensure that the voice of the global judiciary continues to resonate powerfully within the G20, and most importantly, in the lives of the people we serve. This summit will examine the evolving demands on justice systems in a time of political, technological, environmental, and legal transformation, and explore how courts can uphold independence, embrace innovation, and enhance international judicial cooperation. We will, over the next 2 days, confront the question of how we uphold the enduring principles of justice in a world where everything else seems to be shifting. And as we do this, we must be reminded that our independence will keep us steadfast, with the assurance that the judiciary will remain impartial and uphold the rule of law. I will briefly touch upon some of the broad topics that will be discussed today and tomorrow, and how they have manifested and have been addressed in South Africa. I start with judicial independence and accountability, preserving the rule of law, and reinforcing judicial security in an evolving global landscape, which will be addressed in session 1 of the program. As one of the basic structures and premises of the new constitutional text, the South African Constitution establishes a democracy based on the supremacy of the Constitution, protected by an independent judiciary. This includes institutional independence, which can only be achieved if the judiciary enjoys structural, including financial, operational, and perceived independence. Judicial independence is widely understood to be protected by 3 fundamental aspects: security of tenure, financial independence, and administrative control. 3 characteristics which are meant to support the judiciary as an institution, as well as the independence of individual judges from undue external influence. Marking a significant departure from our painful past as a country, the advent of the constitutional dispensation in South Africa introduced a new kind of a judicial system, a judiciary that is independent from other arms of government and is accountable only to the Constitution and the law, which it must apply impartially and without fear, favor, or prejudice. Judicial independence, which has 2 components, individual independence and institutional independence, respectively, referring to the ability of judicial officers to act independently and impartially, and the existence of structures and guarantees to protect our courts and judicial officers from interference by other branches of government, is thus of utmost importance for the courts to effectively play their crucial role and conserve an impartial judicial process. Under the historical governance system of the South African judiciary, the court administration of both the superior courts and the magistracy was controlled by the executive. In 2009, the then Chief Justice, lobbied the executive and began a series of ambitious reforms which were aimed at securing full independence of South Africa's judiciary. In that exercise, the Office of the Chief Justice was established as a national department through a presidential proclamation to provide support to the Chief Justice as the leader of the judiciary and advance the independence and effectiveness of the judiciary. However, this did not bring about an efficient, effective, and accessible justice system because full independence was not achieved. The executive still maintains control over the budget and financial management of the judiciary, which is the heart of the power and ability to meaningfully run anything at all. The judiciary has limited control over key components of court administration, such as the establishment of magistrates' courts, the appointment of magistrates and support staff, security and information technology, with many of our court buildings, especially the magistrates' courts, which serve as courts of first conduct, in poor condition due to years of underfunding and neglect. These systemic challenges adversely affect the lives of the communities we serve and ultimately impede the delivery of justice. As a result of undercapacity and an exponential surge in litigation, courts are faced with heavy backlogs, which result in undue delays of cases. For someone fighting an unfair dismissal or a community, or a community trying to protect their land rights, these delays are not merely frustrating, they are a denial of basic human rights. When funding is misused or delayed, our courts and the people who rely on them are left vulnerable, and the constitutional promise of justice is compromised. The consequences of these challenges are also often deadly. An example of this is the tragic killing of Dingalomoya Chinzo, a witness in a murder trial who was gunned down in broad daylight inside the Wynberg Magistrates Court in Cape Town just in April. There are other examples. Across the country, our courtrooms, entrances, and parking areas often lack a visible security presence, and where security exists, it is frequently rated as poor. In the recent Wynberg incident, private security guards were stationed at the entrance, but the metal detector was not working on that day. This fatality and many others that are occurring in court precincts in our country, especially in the Western Cape, with alarming frequency, highlights the urgent need for meaningful improvements to our court infrastructure, without which the safety of the communities who depend on our courts and the very judicial officers and court staff who are ironically expected to dispense justice in those conditions hangs in the balance. Administrative autonomy for the judiciary is therefore critical to allow judges and magistrates to determine tailored safety protocols suited to court-specific needs and manage infrastructure and resources with greater efficiency and effectiveness. During a judges and magistrates conference held in December 2023, themed towards a single, effective, and fully independent judiciary, the South African judiciary unequivocally called for urgent reforms in the institution, chief of which is full judicial independence. The conference closely examined whether there is sufficient protection and support for judicial independence in South Africa. Among the resolutions it adopted, the judiciary called for a single judiciary encompassing all superior courts and lower courts, as well as for full control over their own administration, budget, and operational functions. It is only on 6 June 2025, a day which marked a watershed moment in the South African judiciary's 15-year-long battle for its autonomy, that the executive, led by the president of the country, with the judiciary, to discuss the long overdue reforms towards the attainment of the independence of this neglected arm of state. That meeting highlighted the importance of cooperation among the branches of government, whilst maintaining a delicate balance and ensuring that they do not overstep the relevant boundaries and encroach into each other's terrain, and prove that it is possible under the principle of separation of powers for the arms of state to support one another as they must to uphold the Constitution. It gives me great delight to announce that the South African judiciary is finally on the path to full institutional independence, and that the technical teams of the executive and the judiciary are working feverishly to bring this constitutional imperative to reality. The other side of the coin, of course, is that while the judiciary is regarded as the guardian of the rule of law and democracy, and the protection of its independence is paramount for it to fulfill its constitutional functions and duties, judicial independence does not mean that the institution stands above scrutiny and is exempted from accountability. The questions who will guard the guards themselves and how the guardians should be guarded are necessary in any constitutional democracy, and it is essential, therefore, that in every judicial system, accountability mechanisms are put in place to ensure that judges and magistrates remain personally and institutionally accountable for their actions and decisions in compliance with constitutional and other legal standards. Judicial accountability in South Africa operates primarily through two mechanisms: the appeal and review process, which allows higher courts to review and overturn decisions of the lower courts, and a formal judicial conduct process led by the Judicial Service Commission, established by the Constitution and involving the President to address gross misconduct, incapacity, or gross incompetence, which may result in a judge's removal from office. Additional to these measures, the Chief Justice accounts to the public by presenting the Judiciary Annual Report on the judiciary's performance and challenges. The Bungalow Principles of Judicial Conduct, which were developed to promote and strengthen judicial accountability in the judiciaries of the United Nations member states, serves as a guide for the regulation of the South African judiciary's conduct and the promotion of ethical behavior within its ranks. And we have used these instruments in finally formulating the sexual harassment policy to which Deputy Chief Justice Mlambo alluded earlier, a few weeks ago, for which there had long been a clamor. Session 2 will deal with the burning subject of artificial intelligence, the key pillar of the second phase of the fourth industrial revolution, which has overtaken almost all aspects of human life and presents unimaginable opportunities for the human race as well as the justice system. We are cautioned to approach this transformation with a balanced perspective, one that enthusiastically acknowledges AI's profound potential to enhance efficiency, reduce crippling backlogs, and lower the cost of legal services. It has been quite exciting to discover that tools for legal research, transcription, and automated administrative functions can free judges to focus on the core human element of adjudication. But while the use of this tool has the potential to be a powerful ally in legal practice, recent cases have also revealed how its misuse can undermine both professional ethics and the integrity of our jurisprudence. This was illustrated in the Northbound case, in which the High Court discovered while drafting its judgment that two cases cited in the applicant's heads of argument actually did not exist. When invited to explain, junior counsel initially claimed that an incorrect version of the heads had been filed, attributing the problem to short-form citations and filing a substituted version. However, opposing counsel pointed out that even the corrected version still contained two non-existent authorities and questioned whether some of the existing authorities were properly applied. Pressed by the court on whether the spurious citations were the product of artificial intelligence hallucinations, counsel considered that they appeared to be so and explained that severe time pressure, the urgency of the matter, and the withdrawal of the original junior counsel had led him to use an online tool called Legal Genius, which claimed to be trained on South African judgments and legislation, but nonetheless generated fabricated references. Fabricated citations undermine the credibility of counsel and the profession, breach the ethical duty of care owed to clients and the court, and threaten the integrity of our jurisprudence by polluting written submissions with fictitious authority. Needless to say, while AI tools can assist research, they are no substitute for independent legal reasoning and rigorous verification of resources. Lawyers who abdicate their professional responsibility to technology risk harming their clients and eroding the trust on which the legal system depends. Perhaps most striking was the case of Mavundla versus MEC, Department of Cooperative Government and Traditional Affairs, in which the court found out that only 2 of the 9 cited cases actually existed, and the judge dismissed the application with punitive costs and referred the matter to the Legal Practice Council. These cases are warning signs that the legal profession must engage proactively with the ethical, procedural, and evidentiary challenges posed by AI. Clearly, if we do not shape the future of AI in law, it will shape us and do so mercilessly. Hearteningly, as South Africa stands at the crossroads of digital transformation, the government has begun laying the groundwork for a national approach to artificial intelligence. On 5 April 2024, our Department of Communications and Digital Technologies published the Artificial Intelligence Planning Discussion Document, which is a foundational text that outlines the state's vision for integrating AI into public and private sectors and proposes the establishment of an AI expert group to work alongside government in shaping a national AI policy with a regulatory framework expected to unfold in the next 2 years. This initiative signals the intent to develop legal principles and governance instruments that ensure that AI is used ethically and responsibly. In August 2024, the National Artificial Intelligence Policy Framework was introduced as the first formal steps towards an AI Act. It emphasizes the need for inclusive, safe, and public interest-driven AI applications, while also calling for investment in AI literacy, local innovation, and improved public data systems to enhance e-government services. It will be interesting to hear how these challenges have manifested and are dealt with in other jurisdictions. Session 3 is concerned with the climate change justice. As we all know, judiciaries across the world are being called upon to adjudicate complex climate cases, often balancing environmental rights with economic development, state obligations, and intergenerational justice. This requires judges to engage in further learning on environmental matters. In a recently launched collection of essays celebrating the 10th anniversary of the South African Judicial Education Institute, its Chief Executive Officer, Dr. Mushweu, and her co-author, Mr. Wabunoha, state that, I quote, "The subject of environmental management is complex and has scientific, technological, economic, social, and equity imperatives that require continuous provision of training to judicial officers, especially with regard to the ever-evolving environmental science. Successful implementation of the law depends on a judiciary that is well equipped to adjudicate matters they preside over," close quote. Judicial education must, of course, keep pace with developments in climate change science and policy. The stakes for ecosystems, for communities, and for future generations could not be higher. Investing in continuous, contextually relevant judicial training is no longer optional, it's an imperative. But no court can address this challenge in isolation. Climate justice demands transnational legal dialogue, the sharing of jurisprudence, and perhaps even joint frameworks for accountability and enforcement. In session 3, our colleagues from France, Australia, Indonesia, and Mozambique will no doubt provide us with helpful pointers for the increasing volume of climate-related litigation and the need for coherent judicial collaboration across borders. This session, therefore, is essential, not as a theoretical exercise, but as a space to equip our cause to act, to innovate, and to reinforce one another. As the climate crisis deepens, so must our resolve as jurists to deliver climate justice fairly, boldly, and collaboratively. The last 2 years have marked a turning point in the evolution of global climate jurisprudence, and 3 landmark advisory opinions delivered by the world's most respected international courts have laid a new legal foundation for climate accountability and state obligations, and I'm sure we'll hear all about those when we get to that session. The last session is concerned with combating cybercrime. In executing its mandate, the South African judicial system is reliant on digital infrastructure, for example, the court online platform and emails for important reasons such as case management, efficient communication, and enhanced public access to legal services. The digitization of court operations through the integration of digital technologies has improved procedural efficiency and arguably access to courts. This transformation was notably accelerated by the COVID-19 pandemic, which necessitated the adoption of virtual hearings and other remote legal processes. However, this digital transformation encompasses significant risks in relation to cybersecurity, for example, ransomware attacks, unauthorized access to sensitive judicial information, and data breaches. Fortunately, South Africa has a robust legal framework governing cybersecurity, and aimed at combating cybercrime. Legislation such as the Cyber Crimes Act, the Protection of Personal Information Act, and Electronic Communications and Transactions Act. As an institution, the Office of the Chief Justice is responsible for the administration of superior courts and is a vital role player in overseeing the digital transformation of judicial processes. The Department of Justice and Constitutional Development also have a responsibility for broader justice sector IT systems and must ensure compliance with cybersecurity legislation. This equips the judiciary with the necessary tools to detect, investigate, and protect our institutions. Although the shift towards digital systems have had significant advantages, it has also introduced new layers of complexity and potential security gaps that require attentive oversight. Given the inherently sensitive nature of the judiciary's infrastructure, it is imperative to implement robust cybersecurity strategies to safeguard the judiciary's electronic and cyber infrastructure from malicious threats. As the judiciary becomes digitized, its vulnerability to cyber attacks grows. In light of this, there is a need to ensure a high standard of cybersecurity, not only in relation to the protection of data, but in preserving the integrity of the justice system and maintaining public confidence in its operations. Therefore, judicial bodies must adopt a proactive and strategic approach to mitigating risks by implementing rigorous information and data protection measures. Another common challenge is the lack of, or rather limited, adequate technological infrastructure within the justice systems, including the availability of computer equipment, reliable and fast internet access, and secure data storage systems. Without a strong electronic and cyber infrastructure, achieving successful implementation of electronic processes can be challenging, and it will be interesting to hear how other jurisdictions are coping with these challenges. The alarming growth rate of cybersecurity threats, which also affect judicial institutions, makes clear that there's an urgent need for a comprehensive and proactive approach to digital security and implementation of robust technical safeguards and organizational practices that collectively strengthen the justice system's digital infrastructure. The measures which are recommended to secure remote connections and protect sensitive data during transmission, such as virtual private networks and multi-factor authentication, touted as significantly reducing the risk of unauthorized access, align with South Africa's broader legal obligations under the Protection of Personal Information Act and the other legislation in that space. We look forward to the exchange of experiences and solutions in this area as well. As I conclude, please allow me to extend in advance our gratitude to the distinguished facilitators of the summit sessions. Their role guiding our discussions with expertise, patience, and insightful direction is the engine of our dialogue. The complex and critical topics on our agenda demand not only knowledge, but also skillful leadership to navigate diverse perspectives, and we are confident that their stewardship will ensure discussions that are productive and enlightening and pave the way for meaningful outcomes. Our appreciation extends to the esteemed panel members who have dedicated significant time and intellectual rigor to prepare for these discussions. We have no doubt that their contributions on the various topics will broaden our understanding and add substantial depth to the collective wisdom assembled here in South Africa today. We also thank every nation represented here. The diverse perspectives from every corner of the world will certainly enrich our discussions immeasurably and remind us that our collective strength lies in our unity and our willingness to listen, learn, and collaborate towards a common future. The arc of the moral universe is long, but it bends towards justice only when we possess the courage to bend it. I trust that we will use this summit to reaffirm our core vows to judicial independence as a shield against coercion, transparency as the antidote for distrust, and unwavering accountability to the people we serve. We have the power to shape the next chapter of global jurisprudence. Let us write one that future generations will look upon with gratitude and pride, a chapter defined by courage, innovation, and an unshakable faith in the enduring power of justice. Thank you.
Thank you very much, Chief Justice. And could I request another round of applause, please, for the CJ? What's going to happen now is I just need to make one correction to, I think, in the protocol list, we should have acknowledged as head of the delegation of Algeria, Justice Abbas Amar. Please accept our apologies for that. And then you would have worked out already the channels for interpretation. Number 1 is for English, number 2 is for French, number 3 is for Portuguese, number 4 is for Turkish, number 5 is Arabia, number 6 is Korean. Thank you very much. And then before I direct the photo shoot process, I just need to introduce the session facilitators because there will be no one to introduce them. I'll start with the session facilitator for the first session after this, the photo shoot. That is Justice Leona Theron from South Africa. Could I ask her to stand up, please? Justice Theron has smashed through glass ceilings during her career. She began a judicial career in 1999 when she was appointed judge of the KwaZulu-Natal Division of the High Court of South Africa. After serving the High Court for 11 years, she was appointed to the Supreme Court of Appeal, and in 2017, she was appointed to the Constitutional Court. The next facilitator for today is Justice Stephen Chong from Singapore. Could I ask Justice Chong to stand up? Thank you. Justice Chong was appointed Judge of Appeal of the Supreme Court in 2017. He served in various roles in the legal profession. Justice Chong was appointed Judicial Commissioner of the Supreme Court on 1 October 2009 and subsequently a Judge of the High Court in June 2010. The next session facilitator is the head of delegation of Algeria, Justice Abbas Amar. Could I ask Justice Amar to stand up, please? Yeah. Justice Amar is the judge of the Constitutional Court in Algeria. He is also a professor in public law. We expect to hear a lot from Justice Amar and his delegation when we deal with AI, how they've navigated transcription services, because we've read about what they've done in that field. The next session facilitator I want to introduce is Justice No Gyonpil from Korea. Justice No is the judge of the Supreme Court in Korea since August 2024. He began his judicial career in 1997 at the Seoul District Court and subsequently served in multiple district and branch courts. He was appointed Justice of the Supreme Court in August 2024, following his tenure as the Chief Presiding Judge of the Suwon High Court. Justice No has established himself as a recognized authority in public law and administrative jurisprudence. Those are the session facilitators I thought I must introduce beforehand. What's going to happen now, we're going to have a photo shoot. And the photo shoot will happen in 3 phases. It involves the international delegations. So without wasting any time, I would request all our international guests to move outside. And then outside, there are protocol officers who are going to direct them how the 3 photos are going to be taken. Could I ask that we do that? And then maybe before you stand up, we have not arranged any tea because we were mindful of time. So when the program continues, when you really feel the urge to grab a cup of tea, you can quietly walk out. There are serving stations outside. You grab your cup and you come back. Thank you very much. So could I request our international guests then to move outside, please?
the President of the Constitutional Court, Judge Kadir Oskaya. Yeah, you can email. We'll just give the delegates who are getting some tea outside a minute or two to join us. Good morning, ma'am. Yes, please. Oh, where is that? No, I've opened. What? Selamat pagi, buong giorno, konnichiwa, dobry utra, sabah al-kai, mehaba, sanbonani, salaikum salam, ayengoshayo. Good morning, ladies and gentlemen. My name is Leona Theron. I happily serve under the Chief Justice of the Republic of South Africa at the Constitutional Court. I have the distinct honor to be your session facilitator for the first session of the summit, and this session is Advancing Judicial Independence and Accountability, Preserving the Rule of Law, and Reinforcing Judicial Security in an Evolving Global Landscape. Judicial independence is not in the personal interests of the judiciary, but in the public interest, because it allows us as judicial officers to perform our duties without fear or favor. Judicial independence is fundamental to democracy. Judicial independence is critical to upholding the rule of law and the separation of powers, foundations that enable our democracies to thrive while ensuring accountability. It's important to recognize that judicial independence operates in two different, though connected, planes. First, it operates on a personal level, where it concerns the independence and impartiality of the individual judge. Second, it operates on an institutional level, where it concerns the independence of the judiciary as an institution and distinct arm of state. The goal of the first session is to share practical strategies for advancing judicial independence and preserving the rule of law in an ever-evolving global landscape. We are here to share experiences, learn from each other, and craft resolutions to reinforce established principles and address common challenges. Some of the questions which should occupy your mind and that of the panelists today are the interconnection between judicial independence and the rule of law, cross-border cooperation to advance into judicial independence, practical ways in which we can inoculate individual judges against threats to their independence and impartiality. We must consider new threats to judicial independence in this evolving global landscape, and solutions to these threats. We must consider how can innovation and technology, alluded to by the Chief Justice of South Africa, such as artificial intelligence, how can it be used to strengthen judicial independence and to enhance judicial accountability? But alongside that, what are the threats that are imposed by technology? And it's my distinct privilege to introduce our first speaker. We had a tete-a-tete last night, and she said, Leona, woman power, we're going to lead the way, we're going to be on time, we're going to be focused, and we're going to show the men who come afterwards how to do it. Lady Chief Justice of England and Wales. She is the first woman to head the judiciary in England and Wales in a history dating back 800 years. Lady Chief Justice will emphasize how the preservation of the rule of law depends on the protection of judicial independence. She will emphasize the interconnection between judicial independence and accountability. And at her speech, when she took her oath of office, guess what she spoke about? Judicial accountability. Colleagues, I give you Lady Chief Justice of England and Wales.
Good morning, colleagues. Thank you for the very warm welcome. It is my distinct pleasure to be here in South Africa for this conference as President of the Courts in England and Wales. Lord Reid, as President of the Supreme Court of the United Kingdom, of course represents the United Kingdom's apex court. As the first guest speaker, may I extend my thanks at the outset to the Chief Justice for her kind invitation and to her officials for organising such a great event when we can all come together to discuss our shared interests and new ideas for tackling common issues. For while our various jurisdictions may differ and we each have our own challenges to overcome, events such as this remind us of our many similarities and our collective commitment to the rule of law, the guiding principle that ensures public confidence and trust in the justice system. I hope to explore, through my brief remarks today, how preservation of the rule of law depends on the protection of judicial independence, the advancement of accountability and public understanding, and the reinforcement of judicial security. All three are needed if we wish to protect and promote the rule of law across all our nations. In England and Wales, like many other jurisdictions, the executive is independent from the judiciary. Judicial independence is not simply a protective mechanism for judges. It gives the rule of law legitimacy. It is its very fabric. The judicial freedom to decide cases without fear or favour, affection or ill will, a fundamental constitutional safeguard, of course reflected in the judicial oath taken in those exact terms. And yet, we live in a world in which that freedom is increasingly under threat. Judicial independence is reliant upon, amongst other things, judicial security. It is a sad sign of an evolving global landscape, a sign of change, that judicial security is now so important a subject to us that it features as a central topic for our discussions this week. Threats to judicial security, of course, aren't new, but in the 2 years since I took up post, I have seen firsthand the increase in threats to the serving judiciary, not only escalation in terms of tone, but also actual violence. And let me say immediately that I am all too aware of the far more serious risks faced by judges in some of the other G20 countries, naming Argentina, Brazil, and Mexico as a few. But nevertheless, for England and Wales, these are new developments. In 2023, we saw a serious physical attack on a senior family judge in court. Crown Court judges, that's criminal judges, received death threats in the 2024 summer riots. It has become commonplace to see inaccurate media reporting leading to dangerous individuals using social media as a platform to make threats or incite anger. Immigration judges, in particular at the moment, are under daily attack in my jurisdiction and security threats. Our recent judicial attitude survey last year, with over a 90% response rate, shows that concerns for personal safety have increased substantially since 2022. In some jurisdictions, Around 70% of judges have such concerns. These security concerns have, I think, a direct impact on the advancement of the rule of law in terms of open justice and transparency. The balance between transparency and security is a delicate one. Put simply, the more open the system, the greater the risks to judicial security. So, at a time when we are looking to the future, embracing technology and its capacity to support not only efficiency, but also increased transparency, we must also address the issues of the present to promote a society in which legitimate debate takes place, but within an environment that is safe for judges and which underpins judicial independence. Threats to judges are not only a matter of personal safety. They represent an attack on the ability of the judiciary to carry out its constitutional role, and by extension, an attack on the democratic process. With this introduction, let me turn to the interconnection between judicial independence and accountability. Maintaining judicial independence does not mean for one moment distancing the courts from the public that they serve. Public confidence depends on integrity in decision-making and understanding how and why decisions are made. In England and Wales, we have a publicly available guide to judicial conduct, setting out the rules and expectations by which we expect all judicial office holders to abide. The guide makes clear that judges must not only be independent, but be seen to be independent. In a world where public trust in institutions cannot be taken for granted, transparency has become more important than ever. In the age of instant communication, heightened public expectation, we must meet a broader demand for accessibility, both in principle and in practice, than ever. So today, transparency is no longer confined simply to the open courtroom. It includes the timely publication of judgments, the responsible use of live streaming, digitization, and the clarity with which reasons are given. In recent years, we have been live streaming and filming and broadcasting court hearings up in, for example, the Court of Appeal Civil Division, hearings in crime, and particularly sentencing remarks in high-profile cases. In April 2024, I created the Transparency and Open Justice Board for the judiciary in England and Wales. Its goal in establishing the board, my goal, is for transparency and open justice to be seen not merely as a bolt-on or a nice-to-have, but rather an integral part of the delivery of justice. The board has been making significant progress, having carried out, amongst other things, a full public engagement exercise to establish its key objectives. Time does not permit the full detail, but the board has already identified 4 practical steps for every court and tribunal in my jurisdiction. Timely and effective access to information about hearings, timely and effective access to the core documents, effective access to hearings in public, and when a hearing cannot be in public, a challenge to all courts and tribunals to consider actively how the principles of open justice can nevertheless be promoted best in that context. Many new initiatives are in place. Skeleton arguments, core documents from the core bundles being made available online in the Court of Appeal, and so on. Public confidence does not require agreement with every outcome, but it does depend on seeing a process that is fair, open, and transparent. When the work of the courts is visible, explained clearly, judicial independence is better understood. So, judicial independence and accountability can be seen as fundamentally compatible, both essential to a justice system that is trusted, effective, and rooted in the rule of law. But returning to the flip side of increased transparency and openness, the increased risk to judicial security. With encouraging increased openness and transparency, it is, I think, really important to be able to recognise openly that with it comes increased risk to judicial security, and to reassure, so far as is possible, that necessary steps to protect the judges are being taken. As I've already said, we have seen a marked increase in media commentary, not only on judgments, but also judges, particularly in the context of immigration. The commentary going beyond reasoned criticism of decisions and becoming attacks on individual identified judges. Such attacks, sometimes based on a misrepresentation of the facts, the reasoning, or even the outcome, provoke violent responses on social media, threats of violence against judges, also their families, doorstepping, doxing. These events all have real-world impacts on judges. So whilst I am fully committed to driving forward the work on ensuring that the courts in England and Wales are as open and transparent as possible, I must also do what I can to ensure that judges are secure and able to carry out their judicial duties without fear for their own, let alone their families' safety. So in January this year, I launched a judicial security task force. It has commissioned the police to conduct a gap analysis between current procedures and an ideal model for judicial protection. One of the first additional actions taken by the task force has been to launch a new online security training course, mandatory for some judges in certain jurisdictions. On physical security, a Ministry of Justice funded agency that supports the operational delivery of our work in the courts and tribunals has received significant capital investment to bring all hearing rooms in England and Wales up to minimum safety standards as an immediate priority, testing and improving panic alarms, safe exit routes, working and effective locks on doors. And we have a new cohort of security liaison judge empowered to bring and respond proactively at a local level to security concerns. And all of this work, I think, is essential. But we also know that the best mitigation is proactively to identify and deal with these risks before they arise. Social media and horizon scanning is increasingly important. Likewise, intelligence agencies and the police must work to identify those individuals who pose a real threat before they are able to strike. What does the future look like in this context to me? My vision for the future is clear: a judiciary that is secure, respected, and trusted, not just for the sake of the judiciary, but to ensure public confidence in the justice system. While judges' safety has indeed become a matter of increasing concern, it remains important that courts remain accessible and visible to the public, central in ensuring public confidence in the legal system. This is a balance that requires careful judgment. Security measures must be proportionate, designed to protect, but without discouraging public participation or making courtrooms feel closed or remote. When necessary, alternative arrangements like remote access may be appropriate, but security measures must support, not diminish, the values that underpin a democratic and transparent system of justice. This will take resource, this will take time, but it is necessary. I see this as continued and increased investment in digital resilience, working with cybersecurity experts, partners, and technology platforms to protect judges from online abuse. We must also continue to embed well-being and support into our working lives as judges, recognising that judicial resilience includes mental health, collegiality, and psychological safety. The burden of maintaining judicial independence does not, of course, fall upon us as judges alone. The independence of the United Kingdom's judiciaries is also a political achievement, one attained through the efforts of the members of the executive and legislative branches of government to defend judges from hostile comments and from those who would attack their motives. We must ensure that ministers uphold their constitutional duty to defend judicial independence. So, in conclusion, the challenges that we face are significant, but they are not insurmountable. The rule of law is sometimes described as fragile, and there is some truth in that. It depends on trust in the fairness of institutions, in the integrity of decision-making, and in the willingness of society to respect judicial decisions. That trust can be tested, particularly in times of political uncertainty, social tension, or rapid global change. It is important to remember that judicial independence, security, and transparency are not competing priorities. They are interrelated pillars of a healthy, functioning democracy. We must continue to invest in safeguarding our judiciary through physical, through digital protections, and by fostering a culture of respect, understanding, and informed public engagement. In short, the judiciary must be open to scrutiny, but never vulnerable to intimidation. Our collective responsibility is to ensure that judges can carry out their duties free from fear and that the public can trust in a system that is both fair and accessible. And in responding to threats, we must reaffirm our commitment to open justice and send a very clear message that no form of intimidation, no form of violence will deter the rightful functioning of our judicial systems. Thank you very much.
Thank you very much, Lady Chief Justice. And she did indeed show the way with 3 minutes to spare. Gentlemen, I'm saying if y'all can beat that. Please, another round of applause for Lady Chief Justice Carr. I invite to the podium Justice Kadir Oskaya, President of the Constitutional Court of the Republic of Turkey. Justice Oskaya will expand upon our responsibility as judicial officers. He is very, very passionate about rendering decisions in accordance with the law and with humanity. I think he heard of Ubuntu before he came here. So he's going to talk about human rights, how to safeguard human rights and freedoms in the face of global conflict. Please welcome Justice Oskaya. Thank you.
Good morning. Sözlerime inandığım bir değerle başlamak istiyorum. Bir insan uzun ömürlü olmak isterse adaletli olsun. Bu durum devletlerde de aynıdır. Adaletli olmak ömrü uzatır. Güney Afrika Cumhuriyeti Anayasa Mahkemesi Başkanı Muhterem Maya Hanımefendi, çok değerli Yüksek Mahkeme Başkanları ve üyeleri, değerli katılımcılar, hanımefendiler, beyefendiler, hepinizi saygıyla, muhabbetle selamlıyorum. Johannesburg'da bulunmaktan büyük bir mutluluk ve onur duyuyorum. Johannesburg benim hafızamda cesaretin, dayanışmanın, adalet uğruna verilen mücadelenin sembolü bir şehir olarak yer almaktadır. Böyle bir şehirde, böylesine önemli bir toplantıyı gerçekleştirmenin insan onuruna ve insan haklarına dair tartışmalara ayrı bir anlam katacağına inanıyorum. Bu harika organizasyon için Sayın Başkan Maya Hanımefendi'yi, mahkeme üyelerini ve emeği geçen herkesi tebrik ediyorum. Organizasyona davetleri için kendilerine en kalbi teşekkürlerimi sunuyorum. Bu önemli organizasyon, siz seçkin meslektaşlarımızla birlikte olmaktan ve sizlere hitap etmekten büyük bir mutluluk duyduğumu ifade etmek istiyorum. Küreselleşen dünyada anayasa yargısı artık yalnızca ulusal sınırlarda değil, evrensel hukuk normları ve uluslararası yargı içtihatları ile şekillenmektedir. Bu nedenle farklı ülkelerin anayasa mahkemeleri ve yüksek yargı organları arasındaki işbirliği, hukukun üstünlüğünü gerçekleştirmek, güçlendirmek, bireysel hakları daha etkili korumak ve küresel çapta adaletin tesisi için kritik bir önem taşımaktadır. Bu organizasyon, anayasa yargısının müşterek sorunlarını birlikte tartışma ve tecrübelerimizi paylaşma fırsatı sunacaktır. Gerçekleştirilecek olan oturumlar, hem aramızda bilgi alışverişine hem de anayasa yargısında karşılaşılan küresel meydan okumalar karşısında ortak çözümler geliştirmeye yönelik verimli tartışmalara zemin hazırlayacaktır. Aynı zamanda katılımcılar olarak aramızda daimi bir iletişim ve etkileşim kanalı kurulmasını sağlayacak olan bu etkinlik vesilesiyle oluşacak ortam, yalnızca bugünü değil, gelecekteki kurumsal ilişkilerimizi de etkileyecek, aramızdaki dayanışma ve işbirliği için önemli bir temel oluşturacaktır. Organizasyonun hem işbirliği hem de akademik anlamda çok faydalı sonuçlara vesile olmasını diliyorum. Değerli dostlar, hepimizin bildiği üzere bundan tam 84 yıl önce Birinci Dünya Savaşı'nın neden olduğu yıkım ve sefaleti henüz tam anlamıyla atlatamamış olan dünya, tarihin en büyük felaketlerinden birisine neden olacak olan İkinci Dünya Savaşı'nın başlamasına tanıklık etti. 1 Eylül 1939'da başlayıp 2 Eylül 1945'te sona eren bu savaş, atom bombalarının kullanıldığı, insan eliyle meydana getirilmiş en büyük felaket olarak tarihe geçti. Savaşta dünya genelinde yaklaşık 110 milyon kişi silah altına alındı, yaklaşık 80 milyon kişi öldü. İnsanlığa derin acılar bırakan bir dönem oldu. Bu trajik süreç toplumsal yapıları sarstı ve kültürel mirasların yok olmasına neden oldu. Umutlar kayboldu, hayaller söndü. Süreç içerisinde dayanışma ve sevgi gibi değerler kayboldu. İnsanlar arasındaki bağlar zayıfladı. Güven duygusu sarsıldı. Toplumsal ve kültürel dinamikler derinden etkilendi. Birçok düşünce ve davranış biçimi yeniden şekillendi. Normlar ve değerler büyük bir değişim sürecine girdi. Değişimler sadece o dönemi değil, sonraki kuşakları da şekillendirerek toplumların kültürel kimliğine derin izler bıraktı. Savaşın ardından gelen dönüşüm süreçleri insanlığın nasıl daha iyi bir gelecek inşa edebileceğini sorgulamasına neden oldu. Barışın ne kadar kıymetli olduğu derinden idrak edildi. Bu idrak toplumlar arasındaki işbirliğini artırdı. İnsan haklarının korunması ve geliştirilmesi konusunda evrensel bir duyarlılık oluştu. Yaşanan acı tecrübelere bağlı olarak uluslararası düzeni ve insan haklarını teminat altına almak için çok taraflı anlaşmalar imzalandı, var olan uluslararası işbirliği yapıları güçlendirildi ve uluslararası yeni mekanizmalar kuruldu. İnsan Hakları Evrensel Bildirgesi birçok insan hakları belgesine ve anlaşmasına kaynaklık etti. Anayasalara ve ulusal belgelere ilham verdi. Bölgesel insan hakları mekanizmaları kurularak ulusüstü koruma sağlandı. Afrika İnsan Hakların ve Hakları Mahkemesi, Avrupa Konseyi ve Avrupa İnsan Hakları Mahkemesi, Inter-Amerikan İnsan Hakları Mahkemesi bunun örnekleri olarak sayılabilir. Bunun yanında insanlığa karşı suçların önlenmesi ve cezalandırılması için de çok taraflı anlaşmalarla uluslararası mahkemeler kuruldu. Yaşanan süreçler, kuvvetler ayrılığının tavizsiz ve sert bir biçimde hayata geçirilmesi gerekliliği gözlemlendi. Bu duruma bağlı olarak da devletin yasama, yürütme ve yargı olarak tanımlanan organlarının birbirlerini sınırlandırması, Bu bağlamda da yargının yasama ve yürütmeden ayrı bir erk olarak fonksiyon icra etmesi gerektiği sonucuna ulaşıldı. Böyle olunca da geçtiğimiz yüzyılda şekillenen modern ulus devlet modelleri kuvvetler ayrılığı ilkesi temelinde yeniden inşa edildi ve yargı ayrı bir erk olarak hayata geçirildi. Bilindiği üzere yargının yasama ve yürütmeden ayrı bir erk olarak fonksiyon icra etmesinin mihenk taşı şüphesiz ki yargı bağımsızlığıdır. Bağımsız bir erk olarak yargı, demokrasi, insan hakları ve hukukun üstünlüğünün temel güvencesidir. Öte yandan insan hak ve özgürlükleriyle hukukun üstünlüğüne dayalı evrensel ortak değerler de demokrasilerin esaslı unsurudurlar. Dolayısıyla demokrasiler için bu değerlerin bağımsız mahkemeler oluşturmak, yeterli hukuki mevzuat ve güvenceler sağlamak suretiyle korunması mutlak bir zorunluluktur. Bunun da ötesinde dünyanın her yerinde, her toplumda o topluma ilişkin anayasal kimliği ya da topluma ilişkin ortak toplumsal kimliği oluşturan ilke ve değerlerin en önemli güvencesi bağımsız ve tarafsız bir yargının varlığıdır. Bağımsız ve tarafsız bir yargının varlığı da ancak o faaliyeti yürütecek olan bağımsız ve tarafsız hakimlerin varlığıyla mümkündür. Hakkın ayakta tutulması ve adaletin sağlanması bakımından en önemli sorumluluk yargısal faaliyetlerin baş aktörleri olan hakim ve savcılara aittir. Dolayısıyla tüm hakim ve savcılar iç dünyalarındaki öznel duygu ve düşünceleri de dahil olmak üzere herhangi bir dışsal etki altında kalmadan, çekinmeden, endişe duymadan, tarafsız bir tutumla pozitif hukuk düzeninin öngördüğü çerçeve içinde özgürce karar vermelidirler. Aklı ve bilimi daima başat bir konumda tutmalıdırlar. Belirtilen durumla birlikte yargı bağımsızlığı elbette büyük bir sorumluluğu da beraberinde getirmektedir. Bağımsızlık bizlere adil ve tarafsız davranma, hukuk ve vicdana göre karar verme ödevi yüklemektedir. Yüksek yargı mensupları olarak bizler, anayasal ilke ve esasların insan hak ve özgürlüklerinin korunması yönünde özel bir sorumluluğa sahibiz. Hepimizin sık sık yakından tecrübe ettiği gibi bu basit bir iş değildir. Vicdanlı, bilinçli ve sorumlu hareket etmek ve adil karar vermek iç dünyamızda ve zihnimizde çok güçlü bir çabayı gerekli kılmaktadır. Yargı bağımsızlığı birçok ülkenin anayasasında ve mevzuatında güvence altına alınmıştır. Benzer şekilde yargıda hesap verilebilirlik için çeşitli usuller öngörülmüştür. Bununla beraber özünde bağımsızlık ve hesap verilebilirlik birbiriyle çatışan ya da en azından yarışan değerlerdir. Bağımsızlık ve hesap verilebilirlik elbette gereklidir. Ancak tek başına anayasal hükümler bunları sağlamaya elverişli değildir. Hatta hem yargısal bağımsızlığın politik amaçlar uğruna göz ardı edildiği hem de hesap verme usullerinin bağımsız yargıçlara karşı kötüye kullanıldığı örnekler mevcuttur. Dolayısıyla yargısal bağımsızlık ve adalet temelinde hareket etmek aslında her şeyden önce biz yargıçların bireysel ve şahsi sorumluluğudur. Az önce ifade ettiğim gibi uyuşmazlıkları adalet, vicdan ve hukuk terazisinde tartmak ve adil bir sonuca varmak entelektüel, vicdani ve zihni gayret gerektiren son derece mühim bir iştir. Esasında kutsal metinlerde de adalete yapılan vurgu bu işin zorluğuna işaret etmektedir. Örneğin Kur'an-ı Kerim'de de çok sayıda ayette adaletle hükmedin buyurulmaktadır. Bunlardan bir tanesi de Maide suresinin 8. ayeti buyruğudur. Şöyle denilmektedir ayette: Ey iman edenler! Allah için hakkı ayakta tutan ve adaletle şahitlik eden kimseler olun. Bir topluluğa duyduğunuz öfke sakın sizi adaletsiz davranmaya sevk etmesin. Takvaya en uygun olanı, en yakışanı budur. Görüldüğü üzere ayette adaletin üstün tutulması, söz konusu olan düşmanlarımız dahi olsa adaletten uzaklaşılmaması gerekliliği açıkça beyan edilmektedir. Değerli dostlar, Türkiye Cumhuriyeti Anayasası'na göre de Hakimler görevlerinde bağımsızdırlar. Anayasa, kanuna ve hukuka uygun olarak vicdani kanaatlerine göre hüküm verirler. Hiçbir organ, makam, merci veya kişi yargı yetkisinin kullanılmasında mahkemelere ve hakimlere emir ve talimat veremez. Genelge gönderemez, tavsiye ve telkinde bulunamaz. Görülmekte olan bir dava hakkında yasama meclisinde yargı yetkisinin kullanılmasıyla ilgili soru sorulamaz, görüşme yapılamaz veya herhangi bir beyanda bulunulamaz. Yasama ve yürütme organları ile idare mahkeme kararlarına uymak zorundadır. Bu organlar ve idare mahkeme kararlarını hiçbir surette değiştiremez ve bunların yerine getirilmesini geciktiremez. Yüksek yargı mensupları olarak yargı bağımsızlığının görevimizin vazgeçilmez bir parçası olduğunu hepimiz çok yakından biliyoruz. Bununla beraber 21. yüzyılın ilk çeyreğini tamamlarken dünya genelinde 2. Dünya Savaşı sırasında ve sonrasında yaşananların unutulduğunu, sanki bunların hiç yaşanılmamış gibi davranıldığını, genel olarak insan haklarına ve hukukun üstünlüğüne, özel olarak da yargı bağımsızlığına karşı sert rüzgarlar estiğini de maalesef müşahede ediyoruz. Oysa o dönem cereyan eden olaylar ve yaşananlar nesiller boyunca dikkate alınması ve geleceğe aktarılması gereken önemli tecrübelerdir. Bugünkü nesiller olarak bu tecrübeleri ve geçmişi gözeterek geleceği inşa etme sorumluluğumuz bulunmaktadır. Bu nedenle birlikte yaşama kültürünü yeşertmek ve daima yeşil tutmak için geçmişe bakmak ve ders almak zorundayız. İnsana dair umut ve iyilik arayışımızı devam ettirmek zorundayız. Dayanışma, sevgi ve güven duygusu gibi değerleri aşındırmadan daima güçlü tutmak zorundayız. Bütün bunlar insanlığın ortak geleceği açısından son derece önemlidir. Bu bağlamda son yıllarda yaşananlar göstermektedir ki insan hakları, hukukun üstünlüğü, uluslararası işbirliği ve kurallara bağlılık, barış, özgürlük, refah gibi temel değerler maalesef hızla erozyona uğramaya, bu değerlerin yerini de askeri ve ekonomik güç, kaba kuvvet ve tabiri değerindeyse zorbalık almaya başladı. Bir yandan savaş ve katliamlar, diğer yandan ekonomik çalkantılar, uluslararası barışı ve düzeni her gün daha çok tehdit eder hale geldi. Hastanelerde, çadırlarda, ibadethanelerde ve buna benzer yerlerde sivillerin, çocukların, yaşlıların her gün bombalanması, diri diri yanmaları, doktorların, gazetecilerin, yardım gönüllülerinin bilinçli olarak hedef alınması, insani yardımların engellenip insanların topluca açlığa mahkum edilmesi olağan olaylar olarak görülmeye başlandı. Maruz kaldığı açlık nedeniyle doğum ağırlığından daha hafif bir ağırlıkta ölen çocukların durumu çok az sayıda kişinin zihninde yer bulabilir hale geldi. Değerli dostlar, Birleşmiş Milletler Genel Sekreterinin 2024 yılı Uluslararası Demokrasi Günü mesajında da belirttiği üzere günümüz itibariyle temel hak ve özgürlükler dünya genelinde çok büyük bir risk altındadır. Özgürlükler aşınıyor, medeni alan daralıyor, kutuplaşma yoğunlaşıyor ve güvensizlik artıyor. Demokrasi, barış ve istikrar için geleceğe dönük kaygılar büyüyor. Dünyanın dört bir yanında güç ve zenginlik kaynaklı üstten bakış, farklı dini inançlara olan düşmanlık, yabancı düşmanlığı, ırkçılık, ayrımcılık gibi sosyolojik virüslerden kaynaklı olarak yaşanan savaşlar, haksızlıklar, zulümler ve eşitsizlikler vicdanlarda derin yaralar açıyor. Barışa, ahlaki değerlere ve adaletin hakimiyetine olan özlem giderek büyüyor. Küresel ölçekte yaşanan derin eşitsizlikler, ağır ekonomik krizler, adil olmayan bölüşüm sistemleri ve uluslararası hukuk ihlalleri göç krizinden çevre felaketine kadar birçok sorunun yapısal nedenleri olarak karşımıza çıkıyor ve ne yazık ki uluslararası toplumun da bu sorunlara geçici çözümlerle yaklaştığı, hatta çoğu zaman gözünü ve vicdanını kapattığı gözlemleniyor. Bu durum uluslararası barış ve düzene, temel ilke ve esaslara ağır darbeler vurmaktadır. Söz konusu kuralsızlık ve aşırılığın yıkıcı etkileri yalnızca yaşanılan yerlerle sınırlı kalmayacaktır. Hem uluslararası ilişkilerin hem de her bir ülke toplumunun geleceğine de şamil olacaktır. Hatta gelecek nesilleri de etkisi altına alacak bir yozlaşmayı da beraberinde getirecektir. Dolayısıyla insanlık tüm bu yaşananlara karşı ortak bir vicdanla haykırmak, ortak bir vicdanla hareket etmek zorundadır. Dünyanın dört bir yanında sergilenen zulme, insan hak ve özgürlüklerine ilişkin ihlallere, çocuklar ve kadınlar başta olmak üzere mağdur ve mazlum insanlara karşı yapılan insanlık dışı muamelelere gözler ve vicdanlar kapatılmamalıdır. Yapılan zulümlere ırk, din, dil, renk ve buna benzer hiçbir ayrım yapılmadan bir an önce cesaretle, adaletle müdahale edilmelidir. Bu insan olmanın zorunlu bir sonucu, yaşamsal bir vicdani borcudur. Bu nedenle tüm toplumlar koşulları zorlayarak da olsa işbirliğini güçlendirmek, güveni tesis etmek, mevcut ve gelecek nesilleri güvence altına almak için daha kapsayıcı ve adil bir dünya inşa etmeye çaba sarf etmek zorundadır. Dünya üzerindeki tüm yetkili ve ilgililer işbirliği içinde kazan kazan anlayışına dayalı adalet ve ahlak odaklı bir uluslararası ilişki pratiği geliştirmelidirler. İnsanı merkezine alan, güvenlik ve temel hak ve özgürlük dengesini bozmayan, hukuk devleti anlayışını özümseyip içselleştirmiş bir hukuk kültürünü yaygınlaştırmanın gereklerini yerine getirmelidirler. Değerli dostlar, konuşmamın başında da belirttiğim gibi insanlık geçmişte uluslararası sistemdeki adaletsizliğin, bağnazlığın, güç ve zenginlik kaynaklı üstten bakışın ve güç körlüğünün ötekiyle birlikte barış içinde yaşamayı reddetmenin nelere mal olduğunu ağır bir bedel ödeyerek öğrenmiş bulunmaktadır. Geçmiş unutulmamalıdır. Biz ve öteki ayrımı sürekli olarak tekrar üretilmemelidir. Sonuç olarak insanlık öteki olanla birlikte barış içinde yaşamayı istemek ve bunu sağlayacak dünya düzenini inşa etmek zorundadır. Duyulması ve karşılık verilmesi umuduyla tüm dünyaya sesleniyorum. İnsanlık olarak geleceğimizi kendi ellerimizle çıkmaza düşürmeyelim. Unutmayalım ki barış ancak adalet ve ahlakın hüküm sürdüğü bir dünyada mümkündür. İnsanlığın ortak geleceği ve sürekli barış ancak ahlaki değerlere ve adalete dönülmesiyle, yeryüzünde ahlaki değerlerin ve adaletin hakim kılınmasıyla mümkündür. Gelin bir an önce hep birlikte el ele yeryüzünde ahlaki değerleri ve adaleti hakim kılalım. İnsan olarak, devlet olarak uzun ömürlü olalım. Unutmayalım ki bir insan uzun ömürlü olmak istiyorsa adaletli olsun. Bir devlet uzun ömürlü olmak istiyorsa adaletli olsun. Adaletli olmak ömrü uzatır. Değerli dostlar, dünyanın içinde bulunduğu bugünkü koşullarda insan hak ve özgürlüklerinin korunması, hukukun üstünlüğüne riayet edilmesi, adalet, vicdan, ölçülülük temelinde hareket edilebilmesi bakımından hem ulusal hem de uluslararası ölçekte cesaretli ve güçlü bir bağımsız yargıya ihtiyaç vardır. Zira söz konusu kuralsızlık ve yozlaşma ancak güçlü bir bağımsız yargının hukuk ve vicdanla hareket etmesiyle önlenebilir. Değerli dostlar, sözlerime son verirken benim gözümde ve gönlümde yargı bağımsızlığını ve hukukun üstünlüğünü ete kemiğe büründüren, insan hakları ve denetim görevini hakkıyla ifa ederek adalet anlayışı ve cesaretiyle genç hukukçulara ilham kaynağı olan Güney Afrika Cumhuriyeti Anayasa Mahkemesi Başkan ve üyelerini yürekten tebrik ediyorum. Ayrıca böylesine başarılı bir organizasyon ve misafirperverlik için bir kez daha şükranlarımı sunuyorum. Dünyamızda yaşanan ve insan onurunu ayaklar altına alan tüm muamelelerin son bulması temennisiyle şahsım ve Türkiye Cumhuriyeti Anayasa Mahkemesi üyeleri adına hepinizi saygıyla selamlıyorum. Tüm sevdiklerinizle birlikte yaşayacağınız sağlıklı, huzurlu, uzun ömürler diliyorum. Beni dinlediğiniz için teşekkür ediyorum.
A round of applause for President Oskaya. President Kadir Oskaya. Thank you very much. We can hear and feel your passion for human rights. Thank you, thank you. The land of cricket, Justice Viswanathan from the Supreme Court of India. He will talk about the historical foundations of the rule of law in India. He will also talk about judicial security, judicial accountability. He will consider global perspectives and how we can learn from each other. And particularly important for this summit, he'll talk about cross-border judicial cooperation. Please welcome Justice Viswanathan.
Distinguished Chief Justice of the Constitutional Court of South Africa, Chief Justice Mandisa Maya, distinguished panelists, dignitaries of the dais, esteemed jurists, ladies and gentlemen, a very good afternoon to you. At the outset, let me convey to the Chief Justice of the Constitutional Court of South Africa and all the delegates the greetings from the Chief Justice of India, Justice Gawai, my distinguished colleague, Justice Vijay Bishnoi, who is here, and on behalf of all the members of the Indian judiciary, and congratulate South Africa for hosting this conference on topics of seminal importance. It is a profound privilege to address you today on a theme that is central to the health of democracy itself. How do we advance judicial independence and accountability, preserve the rule of law, and reinforce judicial security, all within the challenges of an evolving global landscape? India and South Africa, though separated by oceans, are united by history and ideals. Both emerged from deep struggles. India from colonial subjugation, South Africa from the long night of apartheid. And in both, the judiciary often stood as the sentinel of liberty, keeping alive the promise of equality and human dignity when other institutions faltered. President Nelson Mandela, a huge inspirational figure in India, recognized that even the most oppressive regimes can be constrained by principled judges. Similarly, in our country, Justice H.R. Khanna, whose immortal decision in ADM Jabalpur versus Shivkant Shukla during the emergency period, it remains one of the brightest beacons of constitutional fidelity, observed. If there are three prime requisites of the rule of law, they are a strong bar, an independent judiciary, and an enlightened public opinion. These requisites are as relevant today as they were half a century ago, for without them, liberty is fragile, rights are illusory, and constitutions become mere parchment barriers. Courts may not wield the sword or the purse, but they wield something far greater, the trust of the people, and it is this trust that makes democracy endure. Today, I propose to reflect on how judicial independence has been shaped, why accountability must accompany it, how judicial scrutiny underpins both, and how together they sustain the rule of law in a fast-changing world. An independent judiciary ensures that the executive and the legislative excesses can be checked, that minority rights are protected even against majoritarian sentiment, that the powerful and the powerless stand equal before the law. At the outset, I want to deal with two historical events of India which may be of interest to the audience here. In the mid-70s of the previous century, the Indian judiciary was confronted with two important challenges. One was whether Parliament could amend the very constitution itself. Multiple arguments were advanced, but ultimately the Supreme Court stood as the sentinel on the Kavi and said, while constitution can be amended, its essential features or the basic features of the constitution could not be amended. Soon thereafter came an opportunity for the Supreme Court of India to apply this doctrine. When the internal emergency was imposed in India, a constitutional amendment was made, stating that the election of certain high dignitaries were put beyond the anvil of challenge before the judiciary. The constitutional amendment applying the doctrine of basic structure was struck down by the Supreme Court in the landmark judgment of Indira Gandhi versus Raj Narayan. Justice K.K. Matthew, speaking for the court, speaking on rule of law, emphasized, quotation, "I cannot conceive of rule of law as a twinkling star up above the Constitution. To be a basic structure, it must be a terrestrial concept having its habitat within the four corners of the Constitution." It is not surprising because our history and tradition have always stood up for rule of law. The epic Mahabharata deals with the concepts of dharma, used to mean law and the duty interchangeably. Raj Dharma, the duty of the king, and Dharma Raja, the rule of law. The Upanishads, which are the essence of the Vedas, declare that law is the king of kings, far more rigid and powerful than they. There is nothing higher than law by its prowess, as by that of the highest monarch, the weak shall prevail over the strong. The judicial review provided expressly in our Constitution by means of Article 226 and 32 is one of the features upon which hinges the system of checks and balances. Our framers understood the independence without accountability could degenerate into arbitrariness. Thus, the Constitution built both structural safeguards and normative duties. Judges of the Supreme Court of India and the High Courts are appointed by the President after consultation with the Collegium. A security of tenure is ensured with removal only by a process of impeachment for proved misbehavior or incapacity. Article 121 and 211 of the Constitution provide immunity from legislative criticism. The salaries of the judges are charged to the Consolidated Fund of India so that they are not altered to the detriment of the judges. Article 50 of the Constitution talks of separation of judiciary from the executive, and it states that the state shall take steps to separate the judiciary from the executive in the public services of the state. As was emphasized by the speakers before, accountability preserves legitimacy, which is the lifeblood of judicial authority. Accountability in judiciary may take different forms. Reasoned decisions. Every decision must speak through reasons. And the Indian Supreme Court defined reasons to mean reasons being the soul of law and the link between the facts and the conclusion which a judge delivers in his judgment. Judicial conduct, mechanisms for disciplining misconduct without chilling the independence are essential. Public confidence, ultimately judicial legitimacy rests on public trust earned through consistency, fairness, and accessibility. Judicial independence enables judges to follow the facts and law without fear or favor, so as to uphold the rule of law, preserve the separation of governmental powers, and promote due process. Thus, judicial accountability has to be viewed as an instrumental value that promotes three discrete ends: the rule of law, public confidence in courts, and institutional responsibility. Therefore, judicial independence is not an end in itself, but merely a means to an end. With respect to judicial decision-making, the object of judicial independence is to ensure judicial fairness, that judicial decisions are based solely on evidence and law and not influenced by improper or extraneous considerations. With respect to judicial decision-making, judicial independence is a freedom to be fair. With this, we move on to the topic of judicial security. Judicial security encompasses physical, institutional, and procedural measures to protect judges, court staff, and infrastructure from threats and attacks. It is a cornerstone of judicial independence, ensuring that judicial officers can discharge their duties free from intimidation or concern. The concept extends beyond physical safety to include reputational and psychological protection, recognizing that an unthreatened judiciary is a prerequisite for fair and impartial adjudication. As courts continue to address complex disputes, judicial security is viewed not just as a logistical necessity, but as a positive constitutional imperative. The need for judicial security is recognized globally, and robust security is essential for judicial independence. In jurisdictions with heightened risks, threats against judges can hinder impartial adjudication. Across the globe, legal frameworks for judicial protection are evolving to meet contemporary challenges. International standards, such as the UN Basic Principles on Independence of the Judiciary, have long recognized that robust security is essential for judicial independence. South Africa, I notice, integrates judicial security into its broader court administration. The Superior Courts Act of 2013 and the administrative protocols coordinated by the Office of the Chief Justice and National Law Enforcement ensure a more unified and resilient strategy. In India, along the Judges Protection Act of 1985, there is a strong and continuing push for administrative and procedural improvements. The judiciary and government are actively engaged in reinforcing protective mechanisms to better ensure the safety and dignity of judicial officers. The judiciary has stood up to the task. Just to cite a practical example, we had a case in the final decade of the last century as to whether judges could be prosecuted by the executive. While it's true that for criminal misdemeanors, judges ought to be prosecuted, but a screening mechanism was evolved by the Supreme Court of India whereby no first information report or a criminal case could be registered against any of the members of the judiciary without the express sanction of the Chief Justice of India. This has gone a long way in ensuring that the policeman doesn't walk into the judge's house, creating an atmosphere of intimidation. The judiciary is responding to security threats with innovative and decisive action, leveraging technology and proactive mindset to strengthen judicial resilience. Given that judicial institutions are potential targets for cyber attacks, cybersecurity is a top priority. Initiatives focus on robust measures like encryption, intrusion detection systems, and regular security audits to protect sensitive judicial data and records. The National Judicial Data Grid, for instance, has been discussed as a system requiring protected status to ensure its security. Artificial intelligence, a topic with the learned Chief Justice of South Africa dealt with in her insightful address this morning, is being leveraged to both enhance security and streamline judicial processes. In India, the phase 3 of the e-courts project, electronic courts project, integrates AI technologies to enhance case management, improve efficiency, and secure data. The use of technology for physical security is becoming more sophisticated. This includes AI-powered surveillance systems for real-time threat detection and enhanced situational awareness, as well as biometric identification for secure access and control. Judicial adherence to the rule of law is critical in establishing a predictable and stable environment, deterring economic abuses and corruption, and protecting investors and countries from arbitrary treatment. This is where the role of cross-border judicial cooperation assumes primordial significance. It mitigates the risk of financial crisis by enforcing financial regulations and standards. Furthermore, it ensures that every dispute will be subject to an impartial and non-arbitrary legal process which can foster investor confidence and stability in the system. But not just in disputes like money laundering. In environmental law, the cross-border judicial cooperation has become extremely important. The UN Environment Report called Environmental Rule of Law 2019 underscores that although the environmental law put in place since 1972 have increased manifold, failure to fully implement and enforce these laws is one of the greatest challenges to mitigating climate change, reducing pollution, and preventing widespread habitat loss. While there are still gaps in many of the laws, the substantial growth of environmental law has been dramatic. This insight underscores that judicial independence is not merely about safeguarding institutional autonomy, it is also about ensuring that the judiciary remains a steadfast guardian of the rule of law in domains of pressing global concerns. Strengthening judicial cooperation across borders in matters of climate change is therefore an essential dimension of upholding both the rule of law and judicial independence. I want to briefly touch upon the role of judiciary as being an inclusive institution in upholding the rule of law. The role of the judiciary as a reliable, predictable, and vigilant institution is not an abstract legal concept, but a powerful idea rooted in the very mechanisms of economic prosperity, social stability, as articulated by the groundbreaking work of economists Daron Acemoglu, James Robinson, and Simon Johnson. Their theories provide a compelling framework for understanding how the judiciary is not merely a passive arbiter of disputes, but an active catalyst for building a flourishing society. The importance of inclusive institutions is highlighted, and if you contrast what an inclusive and an extractive institution is, the significance becomes clearer. Extractive institutions are those designed to siphon resources and power from the broad population for the benefit of a small, narrow elite. This is a historical norm characterized by the absence of secure property rights, coercion, and general lack of opportunities for the majority. Under such a system, the playing field is tilted to favor those in power, often through the creation of entry barriers to businesses and occupations and a general failure to provide public services for the masses. Inclusive institutions are those that provide incentives and opportunities for innovation and economic activity to a broad cross-section of society. And it is a matter of great pride that judiciaries across the world have today opted for diversity and inclusiveness in their representation. And that is a point I wanted to flag. The evolving global landscape is one of the subtopics of the main topic. What are the challenges? There is technological disruption happening in a big way. Artificial intelligence, with all its biases, is raising serious questions in the adjudication process. Climate change litigation, international trade disputes, and human rights claims require judiciaries to think beyond borders. Courts are often faced with political backlash in protecting minorities. Access to justice, delay itself can threaten. It's said that the very process sometimes becomes the punishment. The topic of artificial intelligence has already been dealt with. I'll quickly rush to the conclusion part. Judicial independence is not merely a national concern, it is a global responsibility. Countless international covenants recognize the rule of law as a cornerstone of peace. The Universal Declaration of Human Rights declares in its preamble, whereas it is essential if man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. Distinguished colleagues, to weaken judicial independence is to imperil the rule of law. To neglect accountability is to imperil legitimacy. Both are indispensable and both must advance together. And let us not forget that judicial independence and accountability cannot endure without judicial security, for judges must be free to decide without fear, protected from threats, both physical and systematic. Our task, therefore, is threefold: to guard judicial independence against executive, legislative, or populist capture, to strengthen accountability through transparency, reasoning, and ethical standards, to remember always that the rule of law is not self-executing. It depends on citizens, lawyers, and judges alike to sustain it. The Constitution is not just a legal document, it is a moral covenant. The judiciary is not just an institution, it is the conscience of that covenant. And the rule of law is not merely a phrase, it is the very architecture of a just society. Let us then, in this evolving global landscape, reaffirm our collective resolve that no one is above law, that justice shall not be delayed or denied, that the court shall remain independent and accountable guardians not of power but of principles. For in preserving judicial independence and accountability, we preserve the rule of law, and in preserving the rule of law, we preserve democracy itself and the democratic institutions. I thank you all for your patient attendance this morning. Thank you for the opportunity. Thank you very much.
Thank you. Thank you, Justice Viswanath. Guardians not of power, but of principle. I like that. And we now go to our distinguished neighbor from Zimbabwe, Chief Justice of Zimbabwe, Justice Malaba. He is also the president of the Conference of Constitutional Jurisdictions of Africa, and it's in that capacity that he speaks to us today, esteemed colleagues. He's going to draw on national and international his national international experience and advise us about collaboration. So please, let's give the Chief Justice of Zimbabwe another warm welcome.
Thank you very much. Director of the proceedings, I start by congratulating our esteemed Chief Justice of South Africa, Chief Justice Lady Maya, for having conceived this very important idea to bring together jurists from different countries who have in common the view of the importance of the fundamental values and principles that undergird human dignity. We say congratulations to you and the judiciary of South Africa. We participate, therefore, to advance the sharing of the experiences from different angles of the understanding of this very important subject matter. The Conference of Constitutional Jurisdictions of Africa, which I lead as president, is made up of 50 members. 50 members who answer to this very important legal norm, constitutional court. And high councils. These are courts created by the fundamental and supreme laws of these 50 member countries. Almost all the constitutions of these countries are based on the fundamental, the foundational value and principle of the rule of law. But their overall objective, the overall objective of these constitutions of Africa is to enforce that very foundational principle of human dignity, the principle that preserves the human being as the fundamental subject of law. There is no law, how supreme, how subordinate it is, that is of relevance to anyone if it does not aim at protecting humanity. These are therefore courts that have a very onerous task of ensuring that the principles found in each of these constitutions for the safeguard of the rights, the fundamental rights of the peoples of Africa are protected, promoted, and fulfilled. The first principle is the rule of law. That is foundational. We have heard the definition of the rule of law is common cause. We all know it as jurists. In simple terms, no one, no institution, no entity, no matter what, is above the law. And that law we are talking about is not just a law. It's a law that complies to the principles of legality. It's a law that complies to the principle that it must be publicly promulgated. It must be equally enforceable. And it must be independently adjudicated upon. That is the foundation of the principle of separation of powers. Underscoring in there is the function, the existence of the judiciary. Underscored in that principle and the principle of rule of law is the function of the judiciary, the role of the judiciary. It is in that respect that we then have a protective principles that enforce the purposes of which is to enforce the principle of the rule of law. These are the principles of the independence of the judiciary. These are the principles that safeguard the judiciary to ensure that it enforces that fundamental principle that no one is above the law, no matter what institution, no matter what person, no matter what entity is above the law. The law is supreme. It is for that purpose, for the purposes of enforcing the rule of law, that the principle of independence of the judiciary gets entrenched in many constitutions I'm talking about. Not only is this constitution a standalone, not only this fundamental principle whose purpose is to enforce the foundational principle of the rule of law, standing alone. It is together with many other principles working holistically towards this function, this purpose, to achieve, to strengthen, protect the rule of law. The sister principle we know is judicial accountability. They go together. Judicial accountability, different from independence of the judiciary, is a principle that does not protect the judiciary from external, outside threats or influence. We all know that the principle of judicial independence is founded on a proclaimed demand for institutional independence, that the judges, the judiciary must be left alone to do what it knows best, respond to the demands of the law and the facts before it. As an institution, it must exist independent of the other organs of government, the executive, the legislature. They have their own function, and that function is not judicial function. It's not to exercise a judicatory function. That function is to make the law. Legislation is to make the law. Judges don't make the law, of course, in a way we do sometimes, but officially it's not. But the executive is there to enforce the law, execute. Those who interpret and make clear the statement of what the law wants and what the intention of the lawgiver is are the judges. They must be left alone to do that, to act in terms of the law that they interpret and apply. But judges are not there to do what they want. They must act in accordance with the law. So they are also bound by the law. They must act in accordance with the law, and they must account. They must account that they have done everything which the law demands them to do properly, and they can do the right thing at the right time in the right manner. In other words, they must demonstrate that they can do that which the law demands them to do efficiently. Do the right thing at the right time in the right way. Do things efficiently. Do things fairly. Do things quickly. Discharge justice expeditiously. Don't delay judgments. That is not accountability. If you issue judgments 3 years after you have heard the cases, that's not accountability, it's corruption. Yes, it's corruption. What are you waiting for? What is happening behind the scenes? Why delay a matter that you must make a decision on? That is accountability. So we bring in the law, the rule of law, in terms of the governance of the judiciary. We bring in the rule of law in terms of this principle of independence of the judiciary, protect it from pressures from external intimidation. You must be free. You must not have a bias. And this is critical. But do it properly. If we do things properly, then we secure ourselves. There's judicial security. That is what we're talking about here. Judicial security is doing things in accordance with the law, in accordance with the rule of law, as demanded by the law. If we get corrupt, we are undoing the accountability principle. Corruption is doing things not for the public, not for the interest of the public, not for public office. It's not answering the duty of public office. It's answering selfishness, self-interest, using an office for personal gain or for the gain of another person. That's corruption. There's no rule of law. Rule of law is undermined. There's no independence of the judiciary in that exercise. Judiciary is abused. Those are the threats you begin to see. Threat doesn't necessarily come from outside only. It will come from ourselves. If we don't act properly, we act in a corrupt manner, we are inviting other forces to come in. There are many threats to these values. The independence of the judiciary. And because independence of the judiciary and accountability and underscore security, if we don't enforce those, we don't enforce independence of the judiciary, we don't uphold accountability, we are exposing our security. We are exposing ourselves. A lot is happening now, which is calling on the judiciary to be much broader, to be more progressive in dealing with the duties before us. We must be more progressive in interpretation. In Africa in particular, where there's a lot of demand for development, there's a lot of demand for change, there's a lot of socio inequality. Global landscape is bearing on us, but let us be careful about that. A number of things are happening. Populism, where some regimes are becoming like enemies of judges. They forget that the system itself demands that it must be upheld by everybody. They identify judges as enemies of the people. It's like judges are now cast as elitist and therefore being put in a situation of being enemies. They are attacked in public, and you can understand what it means to a judge who, after making a case, just because someone in government does not like it, starts to use a position of governance as a public criticism of a judge. It's not constructive criticism, it's criticism purely to intimidate the system. Thank you. I'm coming. So there are many of these that are getting around. Social media. We hear a lot of things happening in the social media about how judges are supposed to act, but how are you influencing a judge by articulating a case in a social media? You are intimidating a judge, you are influencing the judge. These are the threats that we are talking about. These are the underminers of the security, judicial security, because judges begin to feel insecure, they feel threatened, they are no longer in a position of freedom, independence to make their decisions in terms of the law. They are now making decisions in terms of threats. There's no rule of law. Some of us have undertaken, in Zimbabwe, for example, at the moment, we have embraced technological advancement. All our higher courts, constitutional courts, Supreme Court, High Court, are now paperless. But we have realized that in advancing like that, where you have all these technological changes which we have adopted, we have also inherited the evils of it. We have inherited the evils of technology, where the people attempt to attack the system almost on a daily basis. So you need to have strong systems. Once using technology, you must have to balance the effect of these trends so that you can have the rule of law, you have the independence of the judiciary, you have the accountability being vindicated. Thank you. This is exactly zero, she says. I can give it to you later. But anyway, I think what I've done in simple terms is to simplify a paper, which I have there. I'll give it to the organizers to read it, and then have a critic of the paper when I'm not there. Thank you.
Thank you, Chief Justice Malala. Do the right thing at the right time and in the right way. Deputy Chief Justice, could we have an extra 5 or 10 minutes? Oh, thank you very much. Colleagues, we have a few minutes for discussions, comments, questions for the panelists, or just comments you may want to make, anything you want to share from your jurisdiction. I do believe there are roving mics. Justice Collopin from the Constitutional Court of the Republic of South Africa.
Thank you, Program Director. Can I use this mic? Is that okay? Okay, the question and the comment I have is that I think the Chief Justice earlier in this morning spoke about, well, I mean our Chief Justice, sorry, a new and alien class of challenges. And lawyers are often want to say that context is everything. And my question, well, it's a comment and part a question, is that how does one view judicial independence in a context where it is argued that there is democracy in recession? And across the world, we're seeing democracy backsliding, authoritarian rulers, weakening of institutions, and under those circumstances, the judiciary finds itself often in a difficult position when it's almost co-opted either into supporting what majorities want or what authoritarian leaders want. And sometimes that exerts untold pressure on a judiciary. But there are often suggestions that judiciaries might instigate their own backsliding in order to, in a sense, accord with what happens in society. And so there's a concern in some quarters that sometimes judiciaries, instead of protecting democracy, may inadvertently undermine democracy. And I just want to get a sense from the panelists whether this is a concern, and if it is a concern, how does one begin to address that? Because structures and forms are important, but judicial leadership and a culture that you inculcate within the judiciary are equally important. And I think we are privileged in South Africa to have been blessed with leaders who have developed a culture within the judiciary that doesn't depend exclusively on external form, external legal frameworks, important as they are. Thank you.
Thank you. Colleagues, how do we protect judicial independence and accountability in recession? In a recession.
Does this work? Yes. Thank you. Very interesting comments. I think each of us recognized the challenges of change, and I think the context, politically with a small p, is evolving incredibly fast, with politics going in a certain direction, and weakening of institutions you talk about. In my own experience is that we don't feel ever any sort of pressure in the sense that you were talking about to go in one particular direction or another. But I do think we come under pressure to know how to react when we are in a particularly principled position, so we don't speak out, we speak through our judgments. That is the traditional convention. And I think that convention comes under stress when the world is swirling around us and we are being perhaps not as well respected, trusted, or talked about as we used to be. So I think it is, for me, a change in context. The biggest challenges arise in the social media context and the swing of politics. But the other pressures, the wider pressures you talked about on the judiciary, are ones that I'm not familiar with, but others may have different perspectives. I think how we protect ourselves is maintaining a principled, reasoned approach coupled with transparency, improving understanding, enhancing education of why we do what we do and how we do it. But we are in a difficult position because of, certainly in our tradition, the convention that we don't retaliate, We speak through our judgments, and we continue to do the right thing, but that needs people to understand what we're doing.
I'll take one more panelist answer, and then we'll go to another question.
I think it's a very
It's on.
I think it's a very, very important question. I would want to address it conceptually, not with reference to any particular jurisdiction. See, ultimately, the point that you have raised depends on how the individual manning each of the institution reacts to a situation, whether it's the member of the legislature, member of the executive, member of the judiciary. Our constitution makers, at the end of the constitutional debate, both Dr. Ambedkar and President Rajendra Prasad said, however strong your documents are, however strong your constitution is, however good it is, it depends on the men and women who work it. It ultimately depends on that. Whatever be your mechanism, the external documentation. So it comes to that. And the point that the distinguished Chief Justice made in the inaugural address about, while the importance of cooperation with the other organ is important, at the same time, I think the Chief Justice indicated maintenance of a sufficient arm's length in the dispensation of each other's duties. So I would feel that every single judge can make a difference to this, as long as he is conscientious and conscious of the duties that are bestowed upon him. That will be the answer to address any, recession that may happen or any decay that you perceive as being setting in.
Thank you. Unfortunately, we only got time for one more question here in the front from Brazil.
But it's not exactly a question. I just want to share one concern. We are undergoing kind of a unique attack in the Brazilian Supreme Court. As we all know, judicial independence is under attack in many countries with the rise of authoritarian populism and the use of social media to spread disinformation, misinformation, conspiracy theories, and so on. And the erosion of democracy that extremist populism promotes. In Brazil, we were able to resist extremism with a very proactive Supreme Court that voided many of these acts that were eroding democracy, and even launching a criminal investigation against the far right, especially the digital militias that the far right uses. And we're now trying a former president for attacking the institutions and for an attempted coup d'etat with apparently quite a lot of evidence. I'm not part of the judgment because it's in one of the chambers. And we are, of course, under attack of the far right that supports the president. But that's not the point. We are now under international attack. And the justices of the court, 8 of us, we're 11, have had our visas to the United States suspended. They applied a 50% tariffs on all Brazilian goods that go into the United States. And the Magnitsky law was applied to one of the justices. So this is a very unique situation in which judicial independence, it's not under domestic attack, but it's under international attack, which is something I think unheard of. So I'm not even making any comments. I'm just describing a situation, because if this passion spreads throughout the world, then we'll have a problem. So this is just a point I wanted to make, Madam, to kind of raise the concerns of all Supreme Courts in the world that judicial independence can also be under international attack.
Thank you. Thank you very much. I think it's a very important point that you make. Ladies and gentlemen, you're going to allow me now, briefly, I've tried to summarize some of the ideas that came from our esteemed panelists and that can be captured in resolutions. I think what emerged is the following: the importance of judicial independence in the protection of democracy, that there can be tension between judicial independence and judicial accountability. We recognize the importance of technology, but we also got to take steps to save us from the dangers of technology. We note the criticisms, the increased criticisms and attacks on the judiciary's legitimacy. We note the erosion of human rights in some parts of the world. We note the judge's responsibility to maintain judicial independence, to remain impartial, and I think the last point, very important point, the international attacks on domestic independence. All that remains, ladies and gentlemen, is for me to thank our panelists for their valuable contributions and to thank you for your participation. And I think I'm handing over now to the Deputy Chief Justice, who will also remind us about the photographs. Thank you. Thank you very much.
Thank you very much to Justice Theron and the panelists. Please give them another round of applause, please. Thank you. We're going to break for lunch. Lunch is adjacent to this room. The officials are out there. They will guide you where the lunch venue is. And let's make sure we keep to the hour that's been allocated for lunch, and then we come back for the next session. And then the South Africa attendance, the whole delegation from South Africa that's in attendance here, please, you must gather to the front here for a group photo of the attendance, because it's a very important historical occasion. We can't miss it by not capturing in a photo. And then the last thing is the presenters that are still coming. Please ensure that you email your presentations to the email address. I think they will put it up again on the podium here, but it's J20 South Africa @concord.org.za. Yeah, there it is put there. Please, because it assists the interpreters and translators to translate efficiently. So without wasting any of your time, once more, another round of applause for Justice Theron and the panelists. Thank you very much. Could I request my South African colleagues to come up to the podium stage, please?
Thank you, my leader. No, thank you so much. Thank you.
Chief Justices and Judges, distinguished guests, ladies and gentlemen, I trust you had an enjoyable lunch with renewed energy to participate in a robust discussion after the panelists have given their respective speeches. The subject of session 2 is artificial intelligence, which has taken societies, governments, and industries by storm in recent years. It is no exaggeration to say that generative AI is perhaps the defining technology of this decade. As a measure of its impact, you may like to know that investment in AI has skyrocketed, with corporate investment reaching $252 billion in 2024. In the world of lawyers and the courts, the use of AI is quickly gathering momentum. Law firms are using platforms such as Harvey to perform document review, legal research, and even legal analysis. AI has opened up possibilities in predictive analysis to help lawyers consider likely outcomes and build litigation strategies. The courts have not been left behind. Just a few examples. The German courts have used AI in the review of pleadings and to identify case-specific features from the documents. In India, the Supace platform extracts relevant information and locates judgments cited by the parties, and the Supreme People's Court of the People's Republic of China has launched a national-level AI platform that consolidates 320 million pieces of legal information, including court rulings and legal opinions. So the ability of AI to extract information and communicate in a natural language format means that AI holds the potential to radically enhance access to justice, especially for disenfranchised who are most in need of legal solutions but lack the tools and means to engage with the legal system in a meaningful way. At the same time, we who are in the privileged position of shaping the legal and judicial system must be conscious that these are the early stages of the AI revolution. The technology is powerful, but still imperfect. We have all heard of the tendency of generative AI to hallucinate, meaning to generate fictitious content while confirming that it is accurate. There is a worrying growth of cases around the world, and we heard this from Chief Justice Mandisa Maya this morning, where non-existent case law and fabricated quotes have been cited to judges. Other concerns that have been expressed about the use of AI in courts include the so-called opacity problem. The algorithms and training data on which generative AI operates are often invisible to the user. This has led to concerns that data may be skewed in favor of or against a particular group of individuals, and the use of AI tools may further entrench such biases. More fundamentally, there is a view that certain matters should remain solely within the province of human judges because of their moral and social significance, such as decisions of a person's guilt or innocence and the care and custody of children. How then are judges to navigate the unrelenting search of AI into the courtroom and harness its potential to transform access to justice while taking precautions against the risks presented by AI? Courts around the world have issued detailed guidance on the use of AI, and we will hear more about that from our distinguished panelists. Courts have articulated requirements on disclosure of AI use by lawyers and litigants, and courts have also imposed sanctions or issued warnings on the misuse of AI, and this includes referral to regulatory authorities, imposition of court orders, striking out the action in contempt of court. Looking ahead, as AI continues to develop and expand in terms of application, how should judges be thinking about and approaching new AI tools? Let me share with you briefly the Singapore experience. We adopt what we call a traffic light model to navigate the use of AI. Red will refer to areas in which AI should not be tasked to undertake, for example, making decisions on cases. Amber or yellow refers to areas where caution and oversight is needed, such as using AI to draft legal documents, submissions, affidavits, etc., because of the risk of hallucinations. And green refers to low-risk applications, such as to use AI to extract information and to generate summaries. So the potential of AI to transform access to justice and realize fundamental freedoms, the risk of AI presents in its current state, and how we as judges must approach this delicate balance of consideration, these are the difficult questions which the panelists will explore. I believe it is clear to all that AI is here to stay, and therefore we simply cannot afford to ignore its impact on our work as judges. It is thus critical for us to engage in meaningful discussion in order to harness the benefits of AI and yet to remain vigilant of its pitfalls. We have three distinguished panelists. Each of them will be allocated 25 minutes instead of 20 minutes. So they offer very diverse perspective of the use of AI in our judicial system. From a civil law tradition, we have the Chief Justice of Brazil, Luiz Roberto Barroso, who will offer the perspective from the civil law tradition. From the hybrid law tradition, we have the Deputy Chief Justice, Dunstan Mlabo, who requires no introduction. He will provide that unique perspective. And offering a bird's eye and global perspective, we have Mr. Guilherme Canella, who is the Director of the Division for Digital Transformation of UNESCO. So on that note, may I invite Chief Justice Barroso to commence the discussion. Thank you.
Good afternoon. I want in the first place to greet Chief Justice Maya and thank the South African Constitutional Court for the invitation. I'm also delighted to be here, and I want to greet my panel colleagues, Justice Chong, Justice Milambo, and my friend from UNESCO, Guilherme Canella. I have divided this presentation on balancing artificial intelligence innovation with fundamental rights in basically three parts. In the first part, I'm going to talk a little bit about the digital revolution and the rise of artificial intelligence. In the second part, the benefits and risks of artificial intelligence, especially in its use in the judicial system. And in the third part, talk a little bit about regulation and the values, the fundamental rights that we want to protect. So starting with the digital revolution and the rise of artificial intelligence, we still live under the third industrial revolution, the digital revolution that is placed in history in the last decades of the past century, and it's defined by the replacement of the analog technology for a digital technology, and that allowed for the universalization, the spread of personal computers, of smart portable phones, and especially the internet connecting billions of people around the world. We all, especially the older ones, we all had to learn a new vocabulary with words that identify utilities and tools that we didn't know until a few years ago, and without which we could not live any longer. I made a short list here of the ones I know personally: Google, Facebook, Instagram, TikTok, YouTube, WhatsApp, Telegram, Twitter, Waze, Spotify, Netflix, Uber, Dropbox, Skype, FaceTime, and for those who are single, there's also Tinder. So we live this brave new world of information technology, biotechnology, nanotechnology, 3D printing, quantum computing, autonomous cars, Internet of Things, algorithm, which is a word that until a couple years ago we didn't know, is becoming the most important concept of our time. This digital revolution has totally changed the economy, creating this digital economy or this knowledge economy. When I was a bit younger, the most valuable companies in the world were the ones that explored petroleum, like Exxon and Shell, or car manufacturers like General Motors and Ford, or the companies that manufacture the big equipments like General Electric. Well, none of these companies are any longer rated as the most valuable companies in the world, which are Apple, Amazon, Facebook, Google, Microsoft, and NVIDIA with their new names. So there has been a major change in the economy, and of course, this affects dramatically the life of law, and there are several new business models that impact our decisions and, of course, impact the use of artificial intelligence by the judiciary. I just made a short list of new business models. E-commerce, like Alibaba and Amazon, video platforms like YouTube, streaming services for movies and series like Netflix and HBO, music streaming platforms like Spotify and Apple Music, cloud storage services like Dropbox, Google Drive, payment solutions like PayPal, sharing of goods and service platforms like Uber and Airbnb, social media networks, new websites. So we are dealing with novelties that impact constitutional law, impact torts law, impacts taxation, impacts intellectual property, labor law, and the use of AI by the judicial system. A couple words about artificial intelligence. I said at the outset that we were living under the aegis of the third industrial revolution. Well, now we are under the fourth industrial revolution. We are at the dawn of the fourth industrial revolution with artificial intelligence at its core. The focusing specifically in artificial intelligence and giving a very simple definition, we are talking about the transfer of human capacities to computers through softwares. These capacities include cognitive tasks and decision-making more generally. It's conventional wisdom that artificial intelligence doesn't have conscience, doesn't distinguish good from evil, has no feelings, that it's totally dependent on human intelligence to be operated. This conventional wisdom is being challenged more recently, but I will not go down this path. But most scientists agree that with artificial intelligence, we are dealing with an innovation that can be compared to some of the groundbreaking inventions throughout our history, which include fire, the wheel, writing, the electricity, the combustion, internal combustion engine, and medical advances like the antibiotics, like vaccines, like anesthesia, which is a blessing, we could all agree. When we talk about artificial intelligence, this is a general label that has, however, many different fields under it, which include machine learning, include natural language processing, includes computer vision, includes robotics, affective computing, and the one that interests us the most, the generative artificial intelligence, which is this ability to generate content, meaning images, text, music, and art in general. So this is the novelty that is actually stunning the world, the capabilities and the potential of generative artificial intelligence that many people compare to some of the most important events in the history of the world, like the invention of the movable types press and the Enlightenment. So, the artificial intelligence has brought many benefits to humankind, and it has great potential. It's even difficult to systematize all the possibilities on the upside that it offers. I just listed, I made a short list here. Improved decision-making capacity in many areas, just because artificial intelligence has the ability to store much more information than the human brain and has the capacity of processing that information with much higher speed. Other benefits are automation, language. It's very impressive what artificial intelligence has done with language. Whoever needs to translate documents to all different languages will understand that. And very soon, I'll be here talking in English or in Portuguese. That would be much easier for me. And automatically, that would be translated to all different languages. And I've seen that. I've seen a lecture in Portuguese that became, through artificial intelligence, a lecture by the same person in Mandarin. And I'm sure that my friend didn't speak any Chinese. So language is one of the most important benefits that artificial intelligence will bring to the world, and language will not be a barrier anymore. I'm very convinced. Very important role in research and innovation, applications in medicine, applications in the justice system, and I'll be talking in detail about this in a minute. Education and culture, and practical everyday uses like Uber, Waze, Google Maps, personalization of business and other relationships. So I just want to make sure that I see, as many other people see, artificial intelligence as something that can enhance dramatically the quality of life on Earth. However, as we all know, there are many downsides to artificial intelligence, and I made here a short list again. Impact on the labor market, many jobs will disappear, many jobs will be created, but a Uber driver won't become a programmer very easily. So that's something that countries will have to focus on. Something that scares us all, the use of AI for war purposes and for cyber attacks. Thirdly, the risk of mass disinformation and its risks for democracy and freedom of expression, violation of privacy, algorithmic discrimination. There are many issues involving intellectual property that are still being discussed and disputed even in courts. There's a risk to decrease in critical thinking, and there's a major risk that authors point out, which is singularity, which is the risk of the AI computers gaining consciousness and having their proper will, because since they can process information with much more speed and in a much higher amount, they could dominate the world. That sounds like science fiction, but it's a true concern by many of the scientists. There's a passage by Yuval Noah Harari in which he says that scientists agree that the risk of singularity is around 10%. And at first, we think this is a low risk. But then he asks this question: would you board a plane if the engineer that made it would advise you that there was a 10% risk that it would crash, I wouldn't. So there are many concerns about singularity among people that deal with artificial intelligence. So for all these reasons, we need to regulate artificial intelligence. There is, however, a few difficulties with regulating artificial intelligence. First of all, regulation must be implemented with the train in motion. Many scientists, 1,000 of them, called for a pause in the research so that a safety protocol could be developed. No one paused because there is a major race between countries and between companies on developing AI. The second reason why it's very tough to regulate artificial intelligence is that the pace of transformation is astonishing. The traditional telephone, the landline telephone, took 75 years to reach 100 million users. The mobile phone took 16 years to reach 100 million users. The internet took 7 years to reach 100 million users. ChatGPT reached 100 million users in 2 months. That's the pace of transformation that we're living through. And of course, this brings a major difficulty to regulation because we cannot anticipate with great clarity what's coming up next. And besides that, there are risks of excessive regulation stifling the research. There is basically an information asymmetry between regulators and the big techs. That's something that I should stress. And the problem that we need a global harmonization for regulations. And here we're having many problems of extraterritoriality in implementing decisions that refer to artificial intelligence and the use of digital platforms. So this is basically the scenario I wanted to set about the digital revolution and the uses of artificial intelligence, its benefits and risks. And now I want to talk specifically about the use in the judiciary. And in my country, in Brazil, we use a lot of artificial intelligence. Almost 100% of the lawsuits are digitalized. They are electronic lawsuits. We almost don't use paper anymore. And we need to have technology because we have a huge judicialization in Brazil. We have, as of the beginning of 2024, we had 83,800,000 lawsuits pending, going on. And we get 35 million every year, and we decide 35 million every year. So it's not difficult to understand how much we need technology to be able to decide cases with minimum quality and the celerity that, of course, these cases need to be decided. So artificial intelligence has been used for legal research and for precedent research. I come from a civil law country, as our host, our moderator, Justice Chong has mentioned. However, we now combine the civil law tradition with some common law tools. Like we now have binding precedents in Brazil. It's fairly recent, but we were not totally prepared, as the Americans are, to locate precedents. So AI tools have been developed by courts to help judges generally to find precedents relating to the case they are deciding. We have at the Supreme Court, where we get around 70,000 appeals per year, we have a tool that is capable of identifying the cases that we already have precedent so that we can dismiss summarily. And we have tools that will group the appeals according to the subject they deal with so that we can make a precedent and then get rid of a lot of lawsuits. We have a automation of the enforcement of decisions, especially in the Social Security area. We have totally online dispute resolution in some matters. And now I come to the most critically issue. Many courts, and including the Supreme Court, they are all developing AI tools that can make the first draft of judicial decisions, which is a pretty risky business. But when you deal with the amount of cases that we deal, here there is a very important question to ask. Do people have the right to get a human judicial decision, or people have the right to have a quality decision? And in some courts, if you get these statistics, you'll see that judges spend very little time in deciding a huge amount of cases. And for that purpose, AI can be very, very useful as long as we be careful with its use. So the use of artificial intelligence for judicial decision making, for drafting decisions, raises a series of questions, and it's kind of controversial. There are concerns regarding risks of bias, discrimination, lack of transparency. Justice Chong was talking about opacity, and explainability. And it's equally troubling the potential absence of sensitivity, empathy, and compassion in such processes. So these are the main risks that we need to consider when we use artificial intelligence for drafting decisions. However, there is one point here, it's very delicate in this environment, but I think we need to face it. Human judges are equally prone to risks such as bias, discrimination, and undue influence. This highlights another perspective, the possibility that AI could be better equipped to deliver impartial decisions, less influenced by personal interests, political pressures, or intimidation. This potential advantage is particularly significant in less developed countries where they lack judicial independence, and judges can actually be intimidated and suffer undue pressure. So I try to deal with the use of AI in the judicial system in a very careful way, but without any prejudices, because it can be very helpful not only to speed up things, but also to spare judges from undue pressure. But of course, one thing that we can never abdicate is the necessary supervision of humans. And of course, the judge will not dismiss himself of the responsibility for what is being decided. I've seen some judges using artificial intelligence, even in Brazil. They've told me, almost secretly, that they will decide the case, like say motion granted or appeal granted. So they decide the case, but then they ask artificial intelligence to give the grounding, the fundamentals, the motivation of the decision. And then they will, of course, review it. But from what they told me, I haven't done it yet, with great benefit, because it can really do a good job. But of course, the judge is always responsible, and he is the ultimate responsible for any decision that he renders. but I'm just saying that I deem to be inevitable that artificial intelligence will be used in the near future, if it's not already being used, for the drafting of judicial decisions. One last note in these couple minutes that I have left. When I said earlier that artificial intelligence needs regulation, and of course it needs, to protect, I think, three main values: fundamental rights, democracy, and to have a good governance. When I talk about fundamental rights, we are talking about privacy and data protection, including the use of invasive surveillance, such as facial recognition, biometrics, and location tracking. This all should be used in a very controlled manner because it can become a very authoritarian tool. The second fundamental right involved is the right to equality and non-discrimination. The risk of algorithm discrimination we all should be very aware of it. And to protect different kinds of freedoms, including individual autonomy, cognitive freedom, and freedom of expression. Cognitive freedom, because neuroscience has showed that the use of artificial intelligence can not only detect our will and interests, but it can mold our will and interests. They can change our will and interests so that they adjust to their interests, not to ours. So that's what's called cognitive autonomy that needs to be protected. And freedom of expression is always at risk with the kind of moderation that the digital platform can do using or not using artificial intelligence. As for protecting democracy, it's very important to combat disinformation, which has become a major tool for authoritarian regimes on the left and on the right. Fighting hate speech, which most countries do not admit because democracy is a regime that wants to include everyone, and hate speech wants to exclude usually vulnerable groups. I'm going to end in 1 second. And combating, so protect privacy, protect democracy by protecting speech, and combating attacks to democracy. What happened in the US on January the 6th and in Brazil on January 8th of the following year was all articulated through social media and without any kind of control. They were inviting people to invade the buildings of the three branches of government. It was a crime organized online with no detection, with no kind of resistance. And finally, we need to promote good governance with focus on the common good, plural governance, transparency, security, and control and accountability. So I come to my three brief conclusions. The technological digital revolution has brought the world things like the internet, the digital platforms, and AI, and they all can be very important and enhance the quality of our lives and bring positive outcomes. However, the regulation needs to be crafted very carefully so that these tools are not appropriated by bad actors. And artificial intelligence can be extremely useful for the judiciary, but as a general rule, we cannot abdicate of human oversight and the responsibility of the judge. I want to conclude saying that amid all the advancements and transformations, the core existential values that I think should guide us, should guide a meaningful life, remain the very same that have been on for centuries: goodness, justice, the pursuit of truth, and human dignity. Thank you very much.
Thank you very much, Chief Justice Barroso, for sharing perspective from the judiciary from Brazil. And it's quite clear from his presentation that the use of AI is particularly useful in jurisdictions where you have high volume of disputes, because it increases efficiency and because justice delayed is actually justice denied. And it's also quite clear from his presentation that you cannot formulate a policy for AI for to fit all sorts of disputes. AI clearly would be more useful to assist in certain types of disputes as opposed to all types of disputes. So may I now invite the Deputy Chief Justice Malambo to share his perspective, and I believe he will share the unique perspective not just from South Africa, but from the African continent as well. Thank you.
Thank you very much, Justice Chong, and Chief Justice Maya and other Chief Justices here. Please allow me to ride on the protocols we observed this morning. Listening to Chief Justice Barroso nearly prompted me to say I'm willing to donate 10 minutes of my time to him to continue talking. But I'm saying this because you can hear he comes from a jurisdiction that's not at implementation stage, at user stage of AI. And it's an eye-opening insight that you've provided. It's the first time I've heard the justification of using AI to write a decision on the basis that it can be controlled not to be biased, because human beings can be biased. I've never heard that before, but I heard it today. So mine is to take a African perspective. We are, in South Africa in particular, still exploring our journey into AI. How do we use it in the judiciary? But I want to look at South Africa, but look at the continent. I'll cover the same ground as Chief Justice Barroso has covered in terms of benefits, risks, and the way forward. But I start by being very simplistic and giving you the following scenario. Take the case of a young woman in some far-flung rural area, a village, who wants to bring a land claim on behalf of her family, having been dispossessed of their land years before. The court she wants to approach to register this land claim has adopted an AI system to register and allocate cases. That system has been trained only in the Western environment or context and to deal with urban disputes in English. What will happen to her case? So I give you that scenario because her case will definitely be delayed and not be prioritized. And what technology may have promised in terms of speed, it would have produced a courthouse door that was closed to her. I'll give you that scenario. And the question I pose, having given you that, is, in seeking innovation through artificial intelligence, how can African judiciaries ensure that technology serves human dignity and equality rather than eroding fundamental rights or reproducing systemic injustices? This is the challenge before us, to welcome the promise of AI, which means faster case management, broader access to justice, new tools for judges, while refusing to allow biased algorithms, imported systems, or digital exclusion to undermine the very rights and freedoms our courts are sworn to protect. What, therefore, is the promise of AI in African judiciaries? The allure of artificial intelligence in our courts is real. Properly harnessed, as you've heard from the Brazilian example, AI offers powerful tools to enhance justice delivery across Africa. Our continent's jurists and technologists are already pioneering ways to reduce case backlogs, bridge language gaps, automate routine tasks, and increase transparency in the judicial process. Consider the following promising examples and benefits: efficiency and backlog reduction. African courts, global courts as well, contend with significant case backlogs and slow processes. AI is beginning to accelerate case management from smart scheduling to automated case tracking, ensuring swifter resolution of disputes. Take the example of Tanzania. Their AI-driven transcription and translation system handles diverse dialects of Kiswahili as well as English, providing real-time records of proceedings. This relieves judges from clerical duties and helps address the shortage of stenographers. Beyond transcription, Kenya has introduced an e-filing platform that integrates AI-enabled case routing and allocation. Its digital case management system automatically assigns cases to judicial officers, cutting down delays and bottlenecks. These innovations are showing that AI can help courts move from perpetual paper mounds and backlogs to proactive case flow management. Another important benefit: multilingual access to justice. Africa's linguistic diversity has long been a barrier to justice. I'm aware that our colleagues from Algeria may be unhappy about the transcription earlier on. I think it proves the case that language can be a barrier. If you don't hear what the person next to you is saying, you can never have a meaningful discussion. That has been the case in Africa. AI tools are now enabling courts to operate across languages, opening doors for those who speak indigenous languages. In Morocco, AI tools are already being used to draft preliminary judgments and translate legal documents between Arabic and French. This is not a matter of convenience, it is a matter of constitutional access. A litigant can no longer be effectively excluded because he or she does not speak the colonial language of record. Our language of record in South Africa is English. That's our court language. Yet we are a country that has 11, if not 12, official languages. AI, when designed for local context, can transform linguistic exclusion into linguistic inclusion, a step of enormous significance for justice in Africa. Here's another important benefit of AI: automation of routine tasks. Not every form of innovation comes with headlines. Often it is the almost invisible improvements in our systems that make the greatest difference to the daily work of the judiciary. In Kenya's Employment and Labor Relations Court, AI is being tested to fix gaps in digitized judgments where case numbers, party names, or dates are missing. The system scans text, identifies key details, and restores them with accuracy rates of between 82 to 98%, turning incomplete records into usable case records. Why does this matter, you may ask? Because it turns piles of incomplete records into usable, searchable library for precedent. It allows registrars to manage case flow more effectively, helps judges ensure consistency in their decisions, and ultimately reduces delays caused by lost or incomplete files. In short, it is not replacing That is, AI is not replacing judicial work. It is making the underlying system work better, so judges can focus more on substantive justice issues, not paperwork. Chief Justice Barroso mentioned enhanced research capability of AI. One of the greatest burdens of every judge is the sheer volume of material we must consult before reaching a decision. Precedents, statutes, prior rulings, the body of law grows daily, while the time available to resolve cases shrink. Artificial intelligence, when carefully harnessed, offers a way to lighten that burden without compromising judicial performance and independence. In this continent, we're beginning to see how machine learning tools can transform legal research. In Nigeria, the company Law Pavilion has developed a suite of AI-powered research assistants, including Law Pavilion GPT, that can instantly retrieve authorities, generate draft arguments, and summarize complex legal texts. This means that what might have taken long hours of manual searching can now be done in minutes, allowing both judges and practitioners to focus on the substance during hearings rather than the mechanics of trying to find the law. For Africa, these innovations are particularly important. Many of our courts operate under intense pressure, limited resources, heavy backlogs, and an urgent need to maintain public confidence. When legal research becomes faster and judgments more consistent and timeless, the credibility of the judiciary is strengthened. AI does not replace our discretion. It sharpens it, ensuring that justice remains both principled and practical in societies where the demand for fairness far outstrips the available resources. AI also improves transparency and access to justice. Justice does not need to be done, it must be seen to be done. Transparency is the foundation of public confidence, and here too, AI can help African judiciaries make their work more visible, more accessible, and more trusted. In this country, we have invested in court online and case lines, which enable electronic filing and access to records very quickly in seconds, pleadings as well as evidence. Though not AI in themselves, these products, they reduce delays, cut costs, and improve efficiency while providing the digital backbone for future AI in the courts. Imagine if we were to embed an AI tool in our case lines to transcribe into different languages. Can you imagine the relief you'll see? In Rwanda, the integrated case management system connects every arm of the justice chain: courts, prosecution, police, and corrections. Through its digital dashboards, court leaders can monitor backlogs and delays, while litigants can track the progress of their cases online. This has reduced opportunities for files to go missing. We usually joke that files grow legs and run away from court archives. AI will prevent that. It also helps courts automatically remove sensitive personal details before judgments are published, making it easier to share decisions publicly while still protecting privacy. A simple way to strengthen transparency and public trust. These innovations, you will agree with me, illustrate a simple truth. AI, if carefully designed, can make our courts not only faster, but also more accessible and open, more transparent, and more accessible. It can ensure that every litigant, every lawyer, and every citizen sees that justice is not hidden behind closed doors, but delivered in the open, with clarity and accountability. What am I saying? I'm saying the promise of AI in this continent is a faster, more accessible, and perhaps even fairer justice system. It holds the potential to clear long-standing inefficiencies, automating the menial so that humans can focus on the meaningful. It offers to broaden the reach of our courts to every citizen, including those who speak minority languages or live far away from urban legal centers. And it can introduce greater rigor and consistency in judicial reasoning through data-driven insights. Africa is already showing initiative in this space. Our judiciaries are not simply passive recipients of foreign technology. In many cases, they are leading with homegrown innovations tailored to our unique contexts. The task now is to ensure that this innovation remains anchored in inclusion. What are the pitfalls? You've heard from the Brazilian examples. There are risks, there are challenges. And as I want to tell you, for all its promise, AI also brings profound risks. As guardians of fundamental freedoms, African judiciaries must approach AI with a critical eye, mindful of the ways it could undermine the very values we seek to uphold. If adopted incautiously, AI systems could introduce biases, opacity, and new forms of exclusion and rights violations. Let us, therefore, confront these pitfalls directly in the context of our justice systems. There was mention of algorithmic bias and inequality. I don't want to waste time on that, but we know when we glance abroad to the West, we see this algorithmic discrimination hazard. Risk assessment tools used in other jurisdictions have been shown to skew against minority communities and to operate as opaque black boxes. The danger that this brings is acute in Africa. Our multilingual, multicultural societies mean that if AI is not trained on local contexts, it will misread or exclude litigants. Explainability is not a luxury. Parties must be able to test and challenge the reasoning behind decisions. Opaque AI undermines open justice. Our own laws affirm this. South Africa's Protection of Personal Information Act bars decision based solely on automatic processing, where rights are at stake. The principle is clear. In matters of justice, humans, not machines, must remain the final decision makers. I still believe in that, despite what I heard this morning or earlier. The lesson is clear. Bias is not hypothetical. It is a documented risk. Our responsibility is to ensure that innovation serves equality, not exclusion, that AI strengthens dignity rather than codifying discrimination. Privacy and data protection risks. Perhaps the most profound risk AI poses in our courts is a threat to privacy. Every day, our judicial systems handle sensitive information, witness testimonies, medical reports, financial records, and intimate details of family life. If these are fed into AI systems, then we carry a solemn responsibility to ensure that such data is secured and never misused. Improper handling of judicial data does not simply create inconvenience, it threatens dignity itself. The right to privacy is a shield which allows citizens to come before our courts in confidence, to speak openly without fear that their lives will be exposed or manipulated. If that shield is pierced, faith in the justice system would be eroded. The danger is compounded by the fact that across much of Africa, legal frameworks have not yet caught up with the pace of technological adoption. Some countries have, as I've mentioned earlier, begun to close this gap. Kenya's Data Protection Act, Nigeria's Data Protection Act, our own here in South Africa, POPIA Act, all represent important steps. POPIA goes further still, prohibiting any decision based solely on automated processing, where it has a legal effect on an individual, embedding the principle that humans, not machines, must remain accountable. But these laws must not remain words on paper. They must be enforced, updated, and adapted to the specific challenges AI brings to the justice sector. The balance we must strike is delicate but clear. Technology must serve efficiency and security, but never at the expense of privacy. For African judiciaries, this is not a peripheral concern. It is central to our legitimacy. If citizens cannot trust that sensitive information is safeguarded in our courts, then confidence in the justice system is inevitably weakened. Mention has been made of digital exclusion as well as the justice divide. In this continent, as we embrace innovation, we must be honest about who may be left behind. Africa's digital divide risks becoming a justice divide if courts adopt AI without alternatives. A rural claimant with no internet or digital literacy may find the courthouse door invisible. With only 37% or so of Africans online, rapid digitization could tilt justice toward the wealthy and connected, while the poor fall further behind. The divide is also geographic, with urban courts advancing as rural courts are neglected and lag behind. Yet, we also have promising models. I've mentioned Rwanda, I've mentioned Tanzania, I've mentioned Kenya, I've mentioned Morocco, I've mentioned Nigeria. The lesson is simple. Inclusion must be a guiding principle. Our system must provide offline or low-tech pathways so that a litigant without a smartphone is not denied their day in court. They must ensure that the elderly and persons with disabilities are not excluded by interfaces that assume a single kind of litigant or user. If we neglect these considerations, we risk creating a new form of inequality, not between rich and poor, but between those who can access justice through technology and those who cannot. That outcome would undermine not only fairness, but also the very legitimacy of our courts. Judicial independence, we dealt with in the earlier session. There are risks to it posed by AI as well. And those risks are located in legitimacy and due process. That risk we must confront is the danger of artificial intelligence overshadowing human judgment. However sophisticated an AI tool may be, it must never substitute the conscience and discretion of a human judge. If litigants suspect that an opaque algorithm effectively decided their matter, confidence in the fairness of our courts may erode or will erode. This is not only about perception. Due process requires that every party understand and be able to challenge the reasoning behind a decision. That becomes impossible if the rationale lies behind in a machine's black box. Our African Charter on Human and People's Rights enshrines the right to a fair trial and the independence of the judiciary as essential safeguards to liberty. Let me deal with the way forward in the few minutes left to me. And that way forward is located in balancing innovation and rights and in an African framework properly constructed for African justice. Having weighed these risks, what is the answer? How do we embrace the promise of AI without undermining freedoms? The task before us is not passive adoption, but deliberate choice. We must shape AI's role in our courts with balance, ensuring that innovation walks hand in hand with human dignity, independence, and fairness. Allow me then to outline the key pillars of the African framework for balance. Strong legal frameworks and policies. Clear frameworks are essential. The AU's continental AI strategy makes this plain. Each member state must craft policies that put transparency, accountability, and inclusivity at the center. Countries are responding. South Africa's draft national AI policy framework stresses that AI development must serve constitutional rights and inclusion. These examples show that Africa is shaping its own standards, and our judiciaries must insist that such frameworks explicitly cover courts, data protection, and judicial independence. We need to have in place ethical oversight and governance structures. Laws alone are not enough. We need institutions to uphold them. AI must never operate as a black box in our courts. Oversight committees, whether judicial ethics panels, independent regulators, or even a continental AI governance mechanism as proposed by the AU, can test and certify systems before deployment, monitor their outcomes, and provide remedies when problems arise. I'm happy can tell you that we have already established such a committee in the judiciary in the last session of the SAJA training session, and we look forward to ensuring that we see fruition there. There's also a benefit in judicial training and capacity building. Even the best safeguards fail if those who use AI do not understand it. Judges, magistrate, and court staff must become literate in the strengths and weaknesses of these tools. I've mentioned Tanzania. We need proper investment in infrastructure and digital inclusion. We also need a contextual and inclusive design. African realities must shape African AI. And I repeat this, we should be cautious not to simply source AI products from the West. They are not designed for our context. We need to study our own context, and our own people need to design AI tools that respond to our context. And we need to champion human dignity and justice values. We must measure every technological step against our foundational values. The African Charter on Human and People's Rights enshrines the right to a fair trial and the independence of the judiciary. These principles are not negotiable. As I conclude, I return to the young woman in our opening story. Standing at the courthouse door that technology threatened to close, our collective responsibility is to make sure that that door is opened wide for her and for all of our people, with AI as a tool to help and not a barrier. The promise of AI in African judicial systems is truly exciting. We can imagine high courts that clear their backlogs in months instead of years. Trial courts where interpreters for any language are available at the click of a button. And legal research that once took weeks is now done in minutes. The choice before us is therefore one of governance and will and caution. If we adopt AI with wisdom, transparency, and inclusivity, we can strengthen the rule of law and extend justice more widely than ever before. If we abdicate that responsibility, we risk eroding the very freedoms we are mandated to protect. Let us then commit as judiciaries to lead in this space, to ensure that technology is our servant, never our master, and that innovation always advances rather than diminishes fundamental rights. Thank you very much.
Well, when Deputy Chief Justice Malambo started at the outset that he would be happy to donate 10 minutes, I thought he was overly optimistic. In the end, not only he used his 25 minutes, he exceeded the time. But I think his presentation serves as a very useful and timely reminder that AI is ultimately a tool to assist judges in the administration and management of disputes. Because judging is ultimately a human endeavor. Court users trust the judges. They don't trust artificial intelligence. And I thought Deputy Chief Justice Malambo's presentation also highlights a very important consideration that AI should be built should be tailored to cater for the needs of each jurisdiction. For example, in Africa, they have unique challenges because the users use multiple languages. So you can't have access to justice to the courts unless you speak the same language as the courts. And that's why translation services offered by AI is so critical in a continent like Africa. Now, the third and final speaker is Mr. Canella. He is from UNESCO, and I think he will offer a very unique perspective about capacity building, about raising awareness of AI in the judicial system and the training of judges to be able to harness the benefits of AI and yet remain vigilant about its pitfalls and weaknesses. Mr. Canella, thank you.
Good afternoon, boa tarde, bonjour, buenas tardes. Real pleasure to be here with you. Esteemed Chief Justice Maya, I want on behalf of the UNESCO's Director General, Madame Audrey Azoulay, not only thank you very much for inviting UNESCO to be here, to be a knowledge partner of this summit, but above all for putting together a program that is not only important for the judiciaries. The 4 topics you have chosen are essential topics for our societies today. And they are all cross-cutting, but I would risk to say that this session here is the essential cross-cutting element of the challenges we are facing nowadays for the good and for the bad. Justice Chong, meu querido amigo Presidente Barroso, Deputy Chief Justice Milambo, it's a pleasure to share this panel with you. So I would like to think this 24 minutes presentation now as a Netflix episode. So I will start with a teaser, and the teaser is what I'm going to talk about. So I will start with an apology. After that, I will do a disclaimer, and then I will walk through a chaotic preamble. Then I will be more structured in the AI in the administration of justice. Hopefully, I will reach AI and judicial independence. And then I will conclude with what UNESCO can do for you, since all of you are members of this organization that has 194 member states all represented, also several of you represented in this room. So first was the apology for the interpreters, because I evolved this presentation since we started discussing these topics yesterday evening in the cocktail this morning, and now after listening my fellow panelists. So you have a paper that we have prepared for this conference, but I will speak about something differently, not totally differently, so I apologize for that. The disclaimer that I guess is a very important one, 2 important disclaimers, is that I am a different animal here. I'm not a judge, as you have already noticed, I guess. I'm an international bureaucrat. So I do hope you are not disappointed, but that's what you got. So but it's important for framing what I'm going to say. The second important disclaimer, believe you or not, what I'm going to say was not prepared with the assistance of artificial intelligence. Was actually prepared with the assistance of a lot of human intelligence from my team, myself, and so on. But I did ask, before standing up here, ChatGPT, what it would think I should tell you. And surprisingly, the 3 main topics the chat told me is precisely the things I'm going to tell you anyways, but I wanted to make this disclaimer from the outset. It said, the first thing, AI must serve justice, not replace it. The second one, transparency, accountability, and explainability are non-negotiable. Deputy Chief Justice also just said that. And third thing, judges must lead AI governance, not merely respond to it. So anyways, as I said, I haven't used it, but I'm going to say exactly the same stories. So let me go now to my chaotic preamble. And the first thing I want to say in this chaotic preamble is what is the most important thing you need to retain from this presentation. Therefore, I'm offering you a spoiler to the end. We, UNESCO and the United Nations system, we are celebrating this year our 80th anniversary. And the most important thing is that we need to stick to the principles. Those 30 articles in the Universal Declaration of Human Rights and all the connected elements in the UN Charter and the UNESCO Constitution, as the Chief Justice of Turkey mentioned in his presentation this morning, are the real important things. And I liked the title saying balancing innovation and human rights and artificial intelligence and so on, because I've been participating in the last 1.5 years in several similar gatherings where leaders of the AI industry were in same panels as I was, and they are trying to send a narrative that innovation is opposing the protection of human rights and vice versa. And this is false. It's possible to do both things. Actually, the real innovation, I would argue, is to do those things while protecting human rights and not putting them as they were antagonistic elements in our path forward. So if you need to retain only one thing, you want to go to the toilet, that's it. What then, next element in this chaotic preamble is that what we are discussing here starting this morning is unfortunately one of the greatest risks we are facing in this very moment. That is, there is an overall attack against the accountability systems of our societies. You, the independent judges, but also independent journalists, independent regulators, and the United Nations system, the universal system of human rights. All those things are currently under attack. And it's because they have similarities. Some of you said, while speaking about judicial independence, that you want to judge free from fear or favor. This expression was first used by the publisher of the New York Times in 1896 when he founded the newspaper. We want to do a newspaper without fear or favor. And this is the similarity about the several checks and balances systems of societies, independent judges, independent journalists, independent regulators. So we need to do whatever we can to stop this process of these attacks against the accountability systems. And then technology, including AI, can be an ally in this process, but also can be part of the problem, can be a huge risk. And we need to keep that in mind at all times. Everything I'm going to say here is based on a huge initiative that UNESCO created 12 years ago. It's called UNESCO's Judges Initiative. Actually, the very first partner was the Brazilian Supreme Court, with a former colleague of Justice Barroso, Justice Joaquim Barbosa. And 12 years later, we have engaged 36,000 judges and other judicial operators from 160 countries in this initiative. So what I'm going to say to you in the next 17 minutes is actually telling you what they told us throughout those many years, including about artificial intelligence and their incorporation in its incorporation in administration of justice and judicial independence. And then I just want to underline the things that I'm not going to talk about, but they are also important. The first thing is, as I said, I'm going to structure in the connections of AI with the administration of justice, and then AI and judicial independence. But there is a fourth element that should be very much present when you are discussing AI, that is AI in the actual development of the individual judge. Each one of you and your colleagues, not only while you are exerting your professional activities, but as human beings. Because the more that the AI systems, they dominated the public sphere, the more everything we do is in a way or another influenced by that. And we need to recognize this, otherwise we will have a problem as judges or any other professionals, and these things should be very much acknowledged in this process. The second element I'm not going to talk about, but is very important, and in a way, Justice Barroso offered you some drivers, is when you are taking decisions, judicial decisions, that you need to weigh in the AI factor in your decisions. So it's not using AI to improve the administration of justice, but actually is taking decisions about fundamental freedoms, about elections, about public health, about finances, about privacy, that are influenced by the way these new systems are reshaping the digital ecosystem, therefore our lives. And this is a very, very important discussion that is not the same discussion as administration of justice and judicial independence. I will give you just one example. I thought, Barroso, you were going to mention that, so I was afraid you were going to steal my thunder, but you didn't, so I will use it anyways. The real change, for example, for freedom of expression in this entire discussion is not necessarily the problematic content. We always had hate speech in our lives. The same moment we invented love, we invented hate. We always had disinformation, maybe with different names, lies, propaganda, whatever it is. The very same moment we invented truth, we invented lies. The real difference is what I call the 4 V's, which are the processes: the velocity, the volume, the virality, and the verisimilitude. And all those things, they are exponentially more complicated with AI, especially the last V. Because the fundamental philosophical element behind freedom of expression is that we should agree to disagree. We should even respect speech we don't like it, speech that we think is annoying, disgusting, or whatever. But we have a common element about the facts. So you might like or not like my tie. You might think this is the peace dove. You might think this is any dove. You might even think this is the bird of a particular social media company. But we all agree this is a tie. If you think this is a cat, then the conversation about freedom of expression changes completely the parameter. And with the deepfakes, dear justices, this is what actually is happening. And then it will have serious implications in your decision-making about the protection of those fundamental freedoms, including freedom of expression. Final element of my chaotic preamble is when we say AI, there is a lot of things below this chapeau. It can be generative AI, it can be just algorithmic help to organize things, and in the future can be agency AI and so on and so forth. So for the purpose of this presentation, I'm using the definition of the UNESCO's recommendation on ethics of artificial intelligence that says that AI systems are systems which have the capacity to process data and information in a way that resembles intelligent behavior and typically includes aspects of reasoning, learning, perception, prediction, planning, or control. So now moving to AI in the judicial systems. What we are hearing from our consultations, from our surveys, from your colleagues, key trends, 7 key trends. First one, generative AI is increasingly used by judicial actors worldwide. It seems like obvious, but what I'm saying to you is coming from surveys that we have from 160 countries. So this shows that there is really a global preoccupation and also interaction with this topic. From our surveys, we have that 43%, for example, of the surveyed judges use generative AI to research legislation, jurisprudence, and doctrinal sources, while 28% are employing it for drafting and summarizing texts, emails, and legal arguments. Notably, 14% of respondents also use AI for brainstorming and exploring new legal ideas. So you see that there are different ways and growing ways of using it. Second trend, judiciaries at all levels are actively piloting and in some cases deploying AI tools to tackle distinct courtroom challenges, and particularly the administrative tasks and legal analysis that were already referred both by Justice Barroso and Deputy Chief Justice. Third trend, the lack of IT infrastructure, data, and human resource capacities remain major obstacles to AI development use. And here, of course, the issue of safety is particularly relevant, including cybersecurity, that I understand will be the topic of the last panel tomorrow. Fourth element, non-profit organizations are developing AI solutions for courts. This is a very interesting result of these consultations and surveys we are having, that we talked a lot about the proprietary AI developed by private companies, but there is now more and more non-profit organizations actually trying to support the conversation of AI and judiciary. Think tanks, universities, public universities, and so on. And this is an interesting development that we need to pay attention. Fifth element, AI development in the justice sector is increasingly shaped by new regulations at global, regional, and national levels. And this is a very important development because in the last 2 years, we had important resolutions at the United Nations system level, UNESCO, OECD, European Union, but at least 30 countries have enacted actual laws to govern AI. And definitely this is not only impacting the other areas of government or state, is also impacting the judiciary. Sixth key trend, formal guidance on the use of AI tools in the justice sector remains limited. For example, in our survey with these judges from several jurisdictions, we found that while 44% of judicial operators, including judges, prosecutors, and lawyers, use AI tools like ChatGPT, only 9% have received any sort of institutional training or guidelines to do that. And 7, connected to this, capacity building for the judiciary and AI remains limited, even as judges increasingly face cases related to AI technologies. Now, 3 key points in terms of developing AI strategies for the judiciary. First one, again, obvious things, it's important to define the purpose and the principles for AI using the judiciary. At the end of the day, why do you want to have AI? It's an important question you need to respond. And for that, we have in UNESCO established some blueprints, some guidance for judiciary for your consideration, with 6 building blocks that were all discussed here in a way or another. First one, judicial independence and impartiality is an essential building block of any strategy. How to keep protecting non-negotiable due process and fairness. Third, how to keep protecting human rights. Fourth, transparency and explainability should be a constant concern. And the accountability and oversight mechanisms are very, very relevant. And 6, as the Deputy Chief Justice mentioned at the end of his presentation, it's very important to be concerned with the idea of leaving no one behind. We still have 2.6 billion people disconnected in this planet. 2.6 2.6 billion people disconnected. And among the connected, those that actually have meaningful connectivity are elites in terms of data access, in terms of AI and information literacy, in terms of content in their own languages. So if you decide to completely transform your judicial systems in an entire digital way, you might be risking to leave a lot of people out the system completely for those reasons that I just mentioned. So in the paper, but I won't have time to enter into the details here, in the paper we submitted to the J20, we have then unpacked the six blocking pillars in 15 very concrete actions you can include in your AI plans if you are developing an AI strategy for your judicial systems. Then, of course, is fundamental, the second part, establishing foundation elements that are more related to the infrastructure. So robust IT infrastructure obviously is fundamental for getting AI where you want it. Data management and data protection practices is another important element. Governance structures within the judiciary is another important element. And final important element, guess what? You need money for these things, right? There is no free lunch. So you need to budget what you want to do. And here, also you need to decide if you really need these large language models for what you want. Sometimes people are deciding to use a cannon to kill a mosquito. And that's not necessarily, and it's not efficient in many ways. So there are also small language models that could be even more efficient. And it's connected to the next session tomorrow. These AI systems consume a lot of energy and are impacting the climate as well. So the more you take efficient decisions, the better when you are choosing your AI elements. And then final, the key more pragmatic elements for the AI strategy. First question, you should build by or both? Probably both. And then it's a decision you need to take vis-a-vis of what you want. But the key element here, part of the strategy should be very, very clear procurement rules when you are deciding what you are buying in terms of artificial intelligence applications. You need to prioritize. You can do everything with AI, or almost everything, but it's not wise to start changing everything. What is the prioritization for your courts? As said before, you need to ensure oversight and accountability. And you need to strengthen human capacity and leadership for the AI in the judiciary. And this is particularly relevant because the conversation that I won't be able to extend here, it's very complex. For example, both Justice Barroso and Milambo, they were talking about the biases and what are the things that we should to avoid, the hallucinations and so on. So the bias is a huge problem and in many ways difficult to solve. But there is another problem that is different for bias that Daniel Kahneman and Kassanstad have talked about, the problem of noise. And this problem that's very recurrent in the judiciary, but also in the public health, is a kind of problem that the AI can help a lot. So when we started separating the types of problems we have, maybe we can take less risky decisions regarding AI. And then final element here on the strategy is building collaborations. This is a transnational problem. It requires transnational cooperation, exchange of ideas and knowledge. Then very final words on the issue of judicial independence and the some key drivers here. AI might be an opportunity or a risk for judicial independence. So the challenge is we need to foster the opportunities and mitigate the risks. Easy to say, not that easy to do. And an essential element here, of course, is transparency. Transparency in everything we are doing here. Where your data is stored, how you are dealing with that, how you are taking your decisions. As you heard from a former justice from the US Supreme Court many years ago, the sunshine is the best disinfectant. So here, transparency is fundamental to avoid the problems AI can bring to judicial independence. Then there is a second problem that is related to this, that is the issue of how the motivation of courts' decisions, the right to appeal, the black box problem that is in a way related to transparency, would increase or not the trust in your courts. So in other words, if your citizens, they'd start thinking that they don't know how this is being operated, the risk that they will feel this is impacting judicial independence is very high. And there is a more complicated story here that is the ensuring the control over the AI systems. If you are buying technology that are produced by a handful of companies not even based on your countries, you might be delegating your judicial independence, the control of your processes, to companies that you have zero control over. So this is a very, very important element that you need to consider. And then, of course, the relationship of the AI with the rest of the society is also very important, because you need to keep the independence from the external pressures, including the other branches of government, and how these other players take decisions about AIs, depending on how you have developed your governance, you might impact it. So keep these drivers in mind. But this issue of AI and judicial independence is a brand new issue, and we need to discuss it more. To conclude very briefly, UNESCO, what UNESCO can offer to you. As I said, we have this huge program for capacity building of judicial operators on rule of law and artificial intelligence at your service there, with toolkits, with massive online courses, with training of trainers, materials, and so on. And we have developed, based on a global consultation, a blueprint, guidance for courts that want to implement AI strategies, and if they want to take as reference what other countries are doing, what is the different good practices, but also the mistakes, they can look into this blueprint. So as a conclusion, let's try to avoid the hype. Let's look back and always keeping the key principles, human rights principles in mind. And with that, at least we have solid basis to advance and, as I said, foster the opportunities and mitigate the risks. Thank you very much.
Thank you very much, Mr. Canelo. I was about to auction off this watch, but I was reminded that this belongs to the Chief Justice Barroso. Thank you, Mr. Canelo, for offering this very interesting overview based on his interactions with different jurisdictions all over the world. It's quite clear from his interaction that every judiciary is interested in the use of AI. But his presentation serves, again, as a useful reminder that in order to have a responsible use of AI, there are certain imperatives that you must bear in mind, such as building infrastructure for your tech support, data protection laws, and funding in order to tap the benefits of AI. Now, on that note, may I invite questions from the floor, and I will direct the questions to the panelists. Thank you. Perhaps I will start with the first question. Last week, I paid a visit to the Shenzhen court in China, and there was a demonstration of its AI system. It was a very powerful, a very impressive system, and they gave a demonstration of how it would work. At the end of the presentation, I came away with the impression that AI is particularly useful in a jurisdiction where you have high volume of cases, which was an observation I made when Chief Justice Barroso gave his presentation. But not only high volume of disputes, but where you have a large percentage of litigants who are self-represented in the civil law jurisdiction, which is inquisitorial, unlike the common law system, which is adversarial. So the AI is particularly useful in that kind of situation in being able to draw to the attention of the judge relevant facts which the lay litigant or which in a certain jurisdiction it may not otherwise have been brought to the attention of the judge. So perhaps I can ask Mr. Canelo, from his kind of global perspective, whether he thinks that the AI is particularly useful in jurisdictions where the litigants are self-represented.
Well, I certainly, I think the obvious answer is yes. But if we are thinking on a particular use of the AI, that is this use of reducing backlogs and so on. But as I mentioned, if we look into the broader range of applications of AI, we don't only have large language models, we have small language models, and now we even are talking about tiny devices using AI. So what we are witnessing from our conversations with the different jurisdictions is that there is not one size fits all, and it's a mistake to speak about AI as this very broad umbrella. We need to look into the details of the different applications. And in that sense, and I conclude, I think different jurisdictions with different numbers of cases and so on, they will find interesting ways of using AI as long as they always manage the risks, right?
Yes, thank you.
Sean, can I just add something? In many jurisdictions, in mine, for example, especially in lower courts, you have a lot of repetition. Like in issues involving social security matters, tax matters, and civil servants lawsuits, they are quite repeated. So in these cases, artificial intelligence can be very, very helpful.
Yes.
I think I wanted to echo the same sentiment. When we visited China with the Chief Justice in her previous life, I think it was the same court you visited, Shenzhen. We were exposed to a judge, well, a system that was utilizing AI judges. They call them unashamedly AI judges, but the work allocated to them were the menial, tedious related tasks. To say, we'll deploy 10 AI judges, each one of them disposes of so much per minute or per 5 minutes, but they are all under the supervision of a human judge. So it has nothing to do whether it's a self-represented litigant or whether there's a legal representative there, because that itself may have some sensitivities that because people don't have money, they have to get machine justice. Because people have money, they have to get human justice.
Yes. Any further observations? Yes.
Justice Rogers from the South African Constitutional Court. Perhaps for President Barroso, since you seem to be furthest down the line in actually using AI, I would be just interested to know, firstly, whether you have a common AI system for your entire judiciary, from the highest court down to the what we would call magistrates' courts or the lower levels. Secondly, how it was acquired. Was it somehow built and developed for you? Was it an off-the-shelf system that was just adapted? And how was that procurement aspect handled? And I'd also be interested to know how long that took from when a decision was taken to go that route until it was up and running in your court system.
He's from the Constitutional Court of where? From where?
South Africa.
South Africa. Okay. If there's a common AI system, I wear two hats. I am the Chief Justice, and I'm the President of the National Council of Justice that oversees the entire judiciary. So I'll tell you first what we did at the Supreme Court. We have there basically 4 AI tools. The first one is the one I mentioned that identify among the thousands of appeals we get, which ones have a precedent that has been established so we can dismiss summarily the case. Of course, there is a clerk that oversees it, but it's basically done by artificial intelligence. Second, we have another tool that will group together cases that are similar so that we can decide one of them and then dismiss the other cases and tell the lower courts to apply what we decided. We have a third one called Maria, M-R-I-A, which is in Portuguese artificial intelligence, that makes a brief summary of the proceedings. So you got 20 volumes and you get a summary of 5 pages with the main facts, with the legal issue under discussion, and the previous decisions, and the grounds for the appeal. And that's very, very helpful. And now we have this fourth one that we are still testing, which actually writes a draft of the decision with the instruction that you don't let the program decide the case. You decide the case, the judge decides the case, but then has the program prepare a draft of the motivation, of the grounds of the decision. This is what we have at the court. Then at National Council of Justice, since we moved to a system of precedents, we are investing a lot of energy in a program that will help judges locate precedent. We don't have anything like Nexus, Lexus, as they have in the US. So locating precedents in a system where you decide as many cases as we do, it can be pretty difficult. So it's very useful. And all 91 courts that we have in the country, labor courts and federal courts and state courts, when they can develop their own systems, but they need to notify the National Council of Justice. And if we think it's a good program, it's a good tool, then we generalize for all courts. And so we have courts working in programs that will locate precedents, and we have other courts developing the tools that will draft the decisions. But none of them has been approved so far for general use. But I'm pretty sure we're going to get there very soon for the reasons I mentioned. We have at the Supreme Court 70,000 appeals per year. So we definitely need something that helps us get rid of what's not important. And all over the country, over 80 million lawsuits pending. So it's critical for us to use technology in helping us speed up the delivering justice.
I think there's one aspect of the question which I think you didn't address, and that is the journey it took to have this AI transformation in Brazil.
Well, the one that we use at the court for summaries, we had a bid, and many companies offered, and we picked one, and it's a joint venture that involves Microsoft. But most of them are developed by courts, although they might use some existing generative artificial intelligence like ChatGPT or Claude or Gemini, DeepSeek. There's so many these days. So they are tailor-made, but in certain cases they might use this kind of open source tools.
Okay. Any other? Yes, Chief Justice.
Thank you, Justice Chong. Mine is not a question, but a follow-up with my brother, Deputy Chief Justice Mlambo, on the language issue. Something he said, I'll expatiate a little later, on the language issue, which is critical in South Africa, with 11 official languages, yes, but only one used as a language of court record, English. resulting in the exclusion of tens of millions of ordinary South Africans, from truly accessing justice. DCJ, you and I will continue this conversation offline, but I want to commit you as the chairperson of our judiciary's Information Technology Committee in front of everyone that the scenario, this brilliant scenario you posited of court online having an embedded capacity to translate our court records and judgments into all our languages, simultaneously, just like that. I want to see that happen before you and I retire.
Well, I'm sure with your energy and that of the Deputy Chief Justice, that will come to pass. Yes?
Thank you. My name is Donald Chirwa from the University of Cape Town. There are several other law deans here representing the South African Law Deans Association. We thank the Chief Justice for inviting us to this conference. It's a fascinating conversation that has just happened. AI is more disruptive in our sector, which is higher education. All faculties are struggling with how to teach in this era when students can go to AI and do assignments and pass exams and assessments. In a few years' time, the legal market will be flooded with students who use AI, and we've been struggling to see how we train lawyers in the traditional way, which is difficult at the moment. So the question is, really, if someone is used to using AI, how do they get out of it to check whether AI is answering the question correctly? And to the extent that the judiciary is already using it, we were giggling here as we are fascinated by the fact that some judiciaries have gone far way more into using AI than we thought, which would excite our students that that's a possibility. But there will be scandals, when people know judgments are generated by AI, to whatever extent they are, there will be a scandal here and there. And the question is, to what extent are the judiciaries prepared to deal with those scandals and the consequences for the independence of the judiciary and also the credibility of the judiciary?
It's a very interesting question. Even in Singapore, we struggle with this development. Law students in many universities are now using AI. But if you grew up and were educated in a generation before AI was introduced, you would be sensitive, you would be alert to certain obvious errors which AI might generate. But the concern of students who spend their entire legal education using or applying some form of AI, that sensitivity, that training might be missing, which would affect their development as lawyers. So on that note, may I invite some observations from the panel members?
Yeah, I think this issue is very, very troublesome. My experience with generative AI is that it can be very, very helpful if you are familiar with the subject you're dealing with.
Correct.
Then you can pick some ideas or a roadmap or an insight that you didn't have. But if you're not familiar with the subject, it can take you nowhere, or it can take you to the wrong places.
Absolutely.
So that's the first thing. The second, I'm a law professor myself, and just this week I selected the projects for the doctoral program of my university. The impression I had was the project, you need to present like a draft of what your dissertation you want to develop. It improved the quality of the drafts is much better now. And one of my jobs was trying to figure what was done by artificial intelligence and by the student himself. It's very difficult to identify. And I think we are going to live with that. The fact that people will be using artificial intelligence and you won't be able to detect whether it was his personal creation or it was AI. And this is going to happen in all fields, not only with students, in art, in music, in poetry. So I just think we will need to cope with that. And in conclusion, I recall when the television became very popular and I was a child, people thought that television would destroy family life. People wouldn't talk anymore. They would sit and watch television. It really didn't. Then when the calculator came, when I was in high school, people said, well, they won't learn how to do any math operation. And we survived. So I think we won't resist the use of AI. Many times we won't be able to detect it, and we'll have to cope with it.
Well, I mean, it's very true that AI would affect our way of life. But when AI can distort the truth, and ascertainment of the truth is the foundation of the pursuit of justice, that error, margin of error, using AI can have serious consequences.
Yeah. Justice, if I may just add a few elements to what Justice Barroso said. In terms of education in general, of course, for judges, one important question here that, by the way, is not related to AI, is related to education but now much more. It's working. Instead of looking in the idea that people should concentrate in producing the content in a way of keeping memory of different parts of a particular piece of knowledge, we need to teach people to ask good questions. And this is a very important difference with the results of these chats. If you offer an intelligent prompt, then you can get very interesting things. The second element is that you need to ask the chat what were the sources, because then you can challenge if those sources make sense or not in producing that particular result. And third element I want to be further, could be many more, you should consult different chats, because they also differ among the different chats that are available. If we are talking only about generative AI, there are many others. But to conclude, all these three quick things I just said, they are summarized on one important element of our challenge, including in the judiciary, that we need to increase the levels of AI literacy. This means how to use the system, avoiding the pitfalls. It's difficult, but it's not impossible. So if we just have the Ludit approach of let's not use because it's very dangerous, it's not going to work because people will use it anyway. So how we can improve AI literacy is a big challenge.
Sorry, I think what I wanted to say to add to this discussion is, yes, there will be scandals that will come from judges who unwittingly use AI. And I think as leaders in the judiciary, we can't just sit back and say we can't control it. I think we need to try and develop some governance regulation frameworks as to that governs what we use, right? And in the session I mentioned in July, the subcommittee we've created is going to come with a document that guides us as the judiciary leadership. In what instances will AI be allowed to be used? And I mean, a hot topic in that discussion was most of the judges, in fact, all the judges in the room said, each advocate or lawyer must file a certificate saying whether they've used AI or not in their heads. And then when I posed the question to say, but if the judge has used AI, are you going to write a certificate? And they said no. Now, but I think that illustrates the problem. So I don't think we can sit back and say we can't do anything. And from what I'm aware, my daughter is studying at some university, and she tells me that every time after I test, the lecturer produces 2 sets of marks. People having passed by distinctions, simply because they use AI and disregarding those results, and people who wrote normally. And she says, apparently there are AI content detection tools that are used that can detect whatever has been used from AI. And it's one of the things we can use in the regulation environment I'm talking about. Thank you very much.
Yes. Yes, Vishwanath.
Yeah. My question to the panelists, including to you, Stephen, is there is a concern expressed that the use of AI on a large scale could result in huge unemployment, both the legal profession among paralegals and younger members of the bar. And how does it operate in the court scenario? Because a country like India or Brazil with a huge population, where court staff strength in the Supreme Court of India is about 3,000. And will it cut down on employment, or is it a unjustified apprehension?
Yes.
Well, I think this happens whenever a new technology disrupts the previous one. So I think humanity has dealt with this before. And I don't have the statistics by heart, but I recently read that around 60% of the jobs will disappear, but 80% of new jobs will be created. So we might have some difficulty with the transition, and we might need some social protection to those who will lose their employments. But I think over time, things will settle very reasonably.
Yes. This is the inevitable impact of technology. Yes.
Thank you very much for a fascinating discussion. My name is Mbegezeli Benjamin. I'm from Judges Matter. I have one quick question, Chief Justice Barroso. You mentioned that do people have a right to a human decision, or do they have a right to a quality decision? I would argue that they're entitled to both, a quality human decision. Because I say so because people usually go to court because they expect that a human being will grapple with the issues. They will be empathetic. They will apply a level of mercy, for example, when it comes to sentencing. And I struggle to imagine how robots or AI technologies can easily do that. And if they can, to what extent? Is it a 90% decision by AI and then the judge comes in at 10% to apply the mercy? Or how do we strike the balance? Because I have this apprehension that people will lose faith in the courts if they believe that judges simply just put it in an AI program, and yes, a decision is produced, a quality decision is produced, but it was very much the AI doing the heavy lifting. And then why bother take your decision to court in the first place if all you could do is just to punch in an AI system? Maybe I'm naive.
Well, I totally agree that we generally need a human to supervise or to make the decision. I have a very short story that illustrates what you just said, and I totally agree. 2 years ago, my daughter got married. We had a party at home, and the Chief Justice at the time, a lady, Rosa Weber, she was a very secluded person, but she was nice enough to come to the wedding. And when she was leaving, I asked her, did you have a good time? Did everything go right? I said, everything. I just couldn't get a suite because the attendant told me it wasn't time yet. I said, oh, come on. I took her to the table where the suites were, and I told the attendant, this is Mrs. Rosa Weber, the Chief Justice of Brazil. She would like a suite. And the lady said, I've told her it's not time yet. And then I say, I am the father of the bride. And she says, it changes nothing. she was following very strictly what she had been told, and she could not humanize it. So I recall my first classes in law that said it's the violation that gives life to the law. So I grabbed the sweets, but then I thought this lady probably doesn't know the school of exegesis in France. She'd probably never read Kelsen, but she was a positivistic, normative, radical, that, the norm could not be flexible in any way. This is an anecdote, but just to show that in many, many cases, you certainly need a human being. But as I said, there are many cases that are repeated, and especially in the appellate level, if the artificial intelligence is confirming the previous judgment, I would feel a bit safer to have AI working. And as I said, I think in my country, with the amount of cases we have, this is not quite an option or a choice. It has become kind of inevitable that we benefit from it. Otherwise, as Justice Chong said, justice would be too delayed. So, but I totally agree. We need human supervision. And I think the best way to do it is, as I said, the judge needs to take the decision. This plaintiff has the right. But now please write a draft for me. That gives me some comfort that there will be a human decision always.
Justice Chong, let me just add one important, I mentioned to you in this discussion, for those who are not aware, it's very important to separate the issue of bias that is one of our key concerns, right? In using AI to take decisions in every aspect of life, including the judicial, with the concept of noise. So if you haven't read, I strongly recommend you to read this book called Noise by Daniel Kahneman Stein and Olivier, I forgot his last name. And they have astonishing examples in the area of the judiciary. I will give you one. A particular researcher analyzed 1.5 million decisions in juvenile courts, and they found out that when the football team of the judges lose in the weekend, the judges are harsh against the adolescents in the following Monday. So this has nothing to do with bias. They are not being biased with against a particular individual. They're against everyone because the football team lose. So what an AI system could do to redistribute delay. So what I'm agreeing with Justice Barroso, there are elements that can actually improve the quality of the decision. And regarding bias, we also need to be very careful. I finish with that. There is a study showing in offering banks deciding if they're lending money or not, they're using AI. So in a particular country, the research found that AI was biased against Afro-descendant population in that country, because they could, through the different elements of the algorithm, identify if the borrower was an Afro-descendant or not. But then they want to check if the same bank and the person, the Afro-descendant person, was going to the actual bank to see a human, if the bias was higher or lower than the AI system. And the bias was much higher if they was actually seeing an actual human. So we need to be very careful in throwing the baby without the dirty water, because not everything is bad, but we need regulation, we need governance, etc. But it's not a yes or no question. It's really in the middle what we need to do here, right?
Can I add something, Mr. Chong?
Yes.
I think we'll come to the day in which the first draft will be prepared by artificial intelligence and it will be public. And if the judge wants to decide differently, he will have an argumentative burden of showing why he is disagreeing. And what I'm saying is we are all going to come to this sometime in the near future or in the more distant future, but I'm pretty certain that this is going to happen.
It's been a very interesting discussion, but I will allow one last question. Yes.
Thank you very much. I would like to ask the question as to how AI can assist us with regards to improving access to justice, and specifically in the sense of with regard to the right to appeal. One of our big problems that we often find is the difficulty of getting the transcriptions done properly and timeously of the audio recordings of the trials to go on to appeal. And then the problems we sometimes have with missing records and all of the other related problems. And one of the other big problems for litigants is related to the cost of the transcriptions. That is actually an inhibitor that does not allow them to take a matter on appeal. And if you're generally just looking at it, how nice would it be to immediately have a transcription? Now I'm Jackie Wessels, I'm the Regional Court President in Limpopo, Far North Province in South Africa. We're very rural, but we're doing a lot of virtual. So testimony, and virtual courts, etc. So when we are doing virtual, we using Teams most of the time, and it provides you with a recording and a transcription. The transcription obviously does not look like, the formatting of it does not look like the normal one we used where the transcribers are doing it. So my big question is whether or not there had been developments in regards to AI transcription service specifically for courts. Have anybody developed something like that? And generally, with regard to the importance of the use of AI for purposes of transcription to actually provide these transcribed court records for purposes of appeal. Thank you.
I would have thought that the accuracy of transcription is ultimately a function of the software you use. And I agree with you that providing transcription definitely will facilitate access to justice. And in some jurisdictions, transcription is provided free. So that will be a policy consideration of the courts rather than a function of AI in itself. So it really depends on the budget of each jurisdiction, but to the extent that every jurisdiction should aim to provide free transcription, I think that is a desirable goal to achieve because that would certainly enhance access to justice. I think we've had a very robust, interesting discussion, but the discussion can continue. You can, I'm sure, send inquiries to our panelists or even to myself. And in time to come, we will continue this conversation. Now, may I wrap up with what I think are kind of where we have achieved consensus from the panel discussion and from the participation from the floor, which we will develop into resolution. Number one, I think it's quite clear that the use of AI in judicial system carries much potential for increasing efficiencies in various times, in various tasks, which will generate savings of time and cost, and it has the potential to enhance access to justice. That's one resolution which I think is quite clear that we are on common ground. Number two, I think we all recognize the AI in its current state has limitations, and therefore the use of AI in judicial system carries risks and pitfalls, and we must be educated to understand those risks and pitfalls in order to use AI in a responsible manner. That's number two. Number three, I think it is useful for the courts, for all of us, courts to issue guidelines to lawyers and lay litigants to educate them on the use and misuse of generative AI and to issue guidelines on disclosure of the use of generative AI if required to do so by the courts. That's number three. Number four, I think it's important that when you have a new technology which can offer benefits, but yet can be a subject of misuse, it is necessary for the courts to develop and issue appropriate sanctions for the misuse of AI by court users. And finally, I think this is quite an important point, as AI continues to grow in its capabilities, the scope of its application, the court must be kept abreast of the developments to ensure that it can properly oversee the use of AI in judicial system. And dialogues, conferences like this will certainly be very useful to achieve that objective. I think I will leave it to the repertoire to finalize the resolutions for discussion tomorrow. Thank you very much for your contributions. Thank you. Great job.
I think this is the last session of the day. We have a gala dinner to which you are all invited. And the officials who are here, is the gala dinner here? Oh, it's in the next building where we had lunch. It's at 7 p.m. Thank you very much. Thanks for making this session a very interactive and robust section. Thank you very much.
Last one. Thank you. Thank you very much. Thank you.